Good morning. We'll call the meeting to order. Hope everyone had a good Thanksgiving. You raise your hand. That means you ate a lot, John. Okay. We'll get the meeting going. A bit of a recap from last meeting. We had some things that we were following up on from last meeting. We clarified some information on vacancies, minimum staffing levels, and addition of the assistant chief to the wage table. We discussed future meeting dates, which we agreed upon to go forward with up to this point. And we talked about some tentative agreement articles, at least 5, 14, 25, 28, and 31. We might have added one, but that's what I have. And then went over some discussed definitions, which we're bringing back to talk about at this meeting, and some other discussion of articles and union calendars. On today, I guess the first thing we'll do is we have the meeting scheduled to go into 5 p.m. Is that correct? To confirm that we're free to go today?
Yes, sir.
Okay, and then confirm future meeting date. Of course, today, which is posted, and today. And then December 10th, we're scheduled to go all day. Third, I'm sorry, tomorrow. I'm thinking tomorrow and said third. So third, we're posted to go from 9 till noon.
Tomorrow.
December 3rd, apologize. And they, December 10th all day, and which we haven't posted yet, of course, and December 11th from 9 until noon. Is that about what?
Yes, sir.
Schedule?
That sounds correct.
Okay, good. Tentative agreement, we sent some tentative agreements on November 13th on Articles 2, 8, 22, 23, and the wage table, with the addition of the chief on there. Do we have some business to address on that?
So we emailed those to you on the 13th.
Yes, ma'am.
If there are any, I guess, are there any discussion, or we can just,
Yes, I'd like to discuss Article 2 recognition.
okay.
Section 3, I mean, why does this section have to be in here? To me, it's redundant.
Just give me a second to pull it up. And we're here, Section 3.
Yes, ma'am.
I'm sorry, I was pulling it up, so I didn't hear your comments.
My question is, why does this section have to be in the contract? It's
So as I discussed
redundant.
in previous meetings, there has been some employees who have either left the union or who have chosen, still in the union, to go through alternative means. I think it's important that we clarify that regardless of their status in the union or the issue, that they are still bound by the contract.
I believe that's already clarified. I mean, it's law. I mean, Texas is a right to work state. We know you don't have to be a member of the union to be represented and enjoy the benefits of the collective bargaining agreement.
Okay, where specifically are you saying in the agreement this is already captured?
In the statute, in law, in our duty to represent fairly. I mean, Texas is,
Yeah, so I think we're talking about different things. The
yeah,
right
if you
to,
could clarify that for me. I don't understand why this language has to be in there.
well, I think Sheree has explained it, and what I'm not understanding is why
I don't understand.
what you think it's repetitive or duplicative of. I think this is clarifying who is subject to the provisions of this collective bargaining agreement. And so if you want to point us to somewhere in 143 or 174 where you think this is already covered, let's look at it, but I don't think Texas being a at-will state has anything to do with, I mean, that has to do with separation and why you can fire an employee. I don't think that has anything to do with what's being stated here, which is who's covered by this agreement.
And I'll also add that to your argument of duplicity, the contract has several points where we reassert or reaffirm issues that are both statutory but also mentioned in other places in the contract. This particular language, even if I disagree that it's repetitive, but even if it is, it's necessary to just address some of the problems that's been having and occurring.
Can we point out some of those problems?
I gave you an example. There are members who have left the union and then want to go through additional avenues to get relief. There are members who are in the union who don't want to go up the chain of command, who've been going to HR or who have went to HR to seek redress, and I just think that that's improper.
You say that they've left the union, they're no longer members, but they're still represented by the contract. They still fall under
Absolutely.
the collective bargaining agreement, correct?
Absolutely, which is why we tell them if they have a problem, they're still required to go through the contractual grievance process. We've had that issue multiple times occur, and that has not happened.
So when a member seeks alternative resolution, as you say, they're directed back to the association.
In some cases, because of the issues that have come up and because the city is bound by additional harassment, just federal regulations, we are required to act. However, we do have to notify the chief. And so what ends up happening is there's dual investigations essentially existing. There's multiple resources being exposed that I believe is improper. Ultimately, it's the process of the union that should control. However, if there was to come some issues from a federal type of investigation, the city needs to be sure that we're covered. This language is necessary to protect the city in telling that employee that you have to go through the contract. It's necessary in confirming those in future things. When you have some AEOC investigator come down, they're not really interested in whether or not there's a collective bargaining agreement. The language in the contract has to control. And you can't just point them to a particular statute because in our contract, we waive parts of 143. And so the contract document needs to be solid and sure that the member is aware that these are their obligations and also that we can point to and say, hey, this is our collective bargaining agreement and it says this in the document.
We as a union are also bound as well by the duty to represent fairly. It's a duty of fair representation. So I'm not understanding. I mean,
Well, this isn't about the union representing fairly. This is about making sure that everybody understands that for example, the grievance process is the process to be utilized under the contract for somebody that's covered by the contract.
so is this an educational issue or a contractual issue? I mean,
I think it's
everybody
both.
should know that the union and the contract are the
Well, but obviously.
avenues.
Obviously, everybody doesn't know because as Sheree said, there have been individuals who would be subject to the contract who are trying to seek alternative grievance
Right,
processes.
but they're sent back to the union.
They are, but the EEOC investigator is not. And so then the city again has to expend necessary resources to essentially discuss an issue that should not have even got that far.
Correct, but if an EEOC investigator comes in, isn't the union subject to that investigation, as you say, as well?
Not if the employee didn't go through the proper channels. If an employee goes outside of the channels and the EEOC receives a complaint, yes, we can direct them back to say that that employee should have been done that, but also the city has to follow special steps to say that we did not, deny them a redress, deny them a chance to resolve that. We have to go through the process, which creates a dual investigation. Yeah, the chief can start his own, but essentially those are special triggers. We still have to do additional side. This language is necessary to prevent that from happening. So then when we did tell an employee, yes, you have to go through the contractual process, it's in here. It's theirs in black and white. And then we can, again, if the EEOC comes down and said that the city didn't do our part, we can say we did, we followed our contractual obligation with that employee.
And how many times has this happened, that the EEOC investigators come down and this has been an issue?
I'm not going to discuss particulars of potential cases, but we've had it happen a few
What's the number?
times.
3, 5,
We've had it
100?
happen. We've had it more than once.
Twice?
more than once.
Okay, well, we'll discuss this in caucus, so we could hold off on this one for now.
Okay.
Are there any additional ones?
On this article, no, ma'am.
And any of the proposed TA articles?
No strikes, no lockout is good. The mileage article is good. I want to discuss Article 23 again. I know we had some discussion last time. I was under the impression we were just going to follow the language in 174.
So I can pull the transcript, but essentially what we
No,
agreed.
you don't need to do
But I'm
that.
saying essentially what we
ahead.
agreed to is that it would be a formal written certified letter. What we clarified at that time is that most of the times it comes in the form of an email, and that was not the preferred communication route for the city. And so we proposed a certified letter. And we also requested that it details specifically monetary increases if that's being sought.
Can you explain that? What,
Again, I could pull the transcript, but the language is, what we agreed to is that if the union was seeking an increase in wages, they would say that they wanted to discuss increase in wages.
well, I mean, that's what the statute says. If there's any economic issues to be discussed,
So the
we notify
statute-
it 120 days
Again,
before the end of the fiscal year.
the statute is very broad. What the contract language is intended to do is to narrow that down. That's what this language says, is that it says that if specifically saying that the certified letter should request increase for monetary compensation. At the previous meeting, we said that it didn't have to include a percentage amount, and it did not have to include a certain dollar amount. It just said that that was one of the things that they wanted to discuss. Just so that we don't have to continue to do this, the statute is an outline. The contract is intended to be very specific to the particular needs and wants of the city and the union.
I mean, the statute, I know you know the statute, but I'm gonna say with compensation or other matter that requires an appropriation of money, then we're bound to give 120 days notice before.
Again,
Fiscal year.
so in previous notifications, it's just said that we want to negotiate the contract. It hasn't specifically addressed any of those things. So the manager requested that the notification be a certified letter as opposed to an email to clarify that the writing portion. And he's also requesting that we clarify an increase in compensation.
Can you give me an example? I mean,
So the
I
letter-
think the statute speaks for itself. And I don't think we need to mess with it.
So what's your question, Joe? I
Well,
mean,
my question is, we're looking to amend statutory law. And I think the statute speaks for itself. I've never had an issue as far as notification of intent to bargain. I've negotiated contracts all over the state. This is the first time it's become an issue. If you're requesting a certified mail, letter, we can agree in principle that, yeah, we'll send you a certified letter. I don't believe that's language that has to be in the contract. I mean, you could do it with a phone call. Hey, Jeff, can you send me a certified letter? Done.
So I disagree. And let me tell you why. If it's not specifically a requirement of the contract, it's not something that you're required to do. Again, the statute says that you have to give written notice. The contract is clarifying how that written notice needs to be presented. That's not an amendment of the statute. That's a clarification of how you want to receive notice.
I believe it's an amendment of the statute. And we can hold on to this for later discussion, but at this point, I don't believe we need to be messing around with this statute.
Well, I think that, go ahead.
no, you go first.
I was just going to say, I think this is intended to address some past practices. I would suggest to you then, if you don't want to agree to change the, was it 107?
Yes, ma'am.
Then I would insist that we have a waiver provision in this that says if 107 is not followed in the initial notice to the city, then the union waives its right to negotiate for that next contract period. Because that is not clearly stated in the statute. That has been an issue. That has been an issue in other cities where it's unclear whether the 120 days notice was actually given, because there's these fluid emails going back and forth. So if the union is willing to agree that if they don't do it precisely in accordance with the statute, that they've waived their right to bargain, then I think that's something to talk about. But otherwise, this is pretty simple. It's not amending the statute, as Sheree said. It's adding an additional piece of information about the method of delivery. Yes, this is just saying what the union is already supposed to be doing anyway. So
Correct.
I feel like we're arguing for unnecessarily, and it's,
Well, we're arguing about an unnecessary section that you proposed.
well, the delivery method, I think, makes sense. And again, the exchange of emails that were purporting to initiate negotiations in the past has been an issue. That has been an issue in other cities. That's not unique to Beaumont, and I think it's appropriate to try to clarify that. And then, so we're not adding a section. It's that's repetitive. The delivery is something new and supplements what's already in 174. And in terms of adding monetary compensation, again, that's already in the statute. So why does that,
That's my question. Why does that need to be there?
why not? It's required anyway. So what's the issue with having it in the statute
It's already in the statute. Why do we,
or having it in the contract?
yeah, why are we repeating issues that have already been, it's law. I know of the cases of the missing of the date. Usually the judge will send the parties back to the table. In some cases, Court Natchez, for instance, missed their deadline. And I told them that you missed the deadline. The city does not have to negotiate with you if they don't want to. But the city manager said, okay, let's go ahead and negotiate.
Sure, it can be cured, but I think, again, unique to this city has been the history of how the negotiations were initiated. And this is trying to prevent any miscommunication about what the expectations are moving forward.
If this statute wasn't in there, Mr. Williams, you could make a phone call and say, can you send me a certified letter? Sure. I mean, it's that simple.
Or they can say no and send an email that says, we want a bargain
Okay.
without the requisite information in 107. And then the city's in the position of having to play defense and say, well, you've waived because you're not in compliance with the statute. Let's just get everybody on the same page and agree to what's going to be sent and what it's going to say, and then we can avoid those issues. That's the whole purpose of the parts of the contract.
The union shall provide a formal notice in the form of certified letter to the city manager, period, and then strike the rest of it.
Okay, if we add, and the union agrees that if it's not in strict compliance with 107, they waive the right to bargain.
Now, I mean, that's already,
It doesn't say that, it does not say in 174 that if it's not in strict compliance, they waive their right to bargain. That's implicated, and then we have to go to court and fight about it. So why not,
well, we're already in court anyway, so.
no, not here, not over this contract, not yet anyway. So
Not yet
let's,
anyway, true.
let's just,
But we're gonna hold on to this one. We'll discuss it in our caucus. We're not ready to TA.
okay.
Well, which is interesting because we did agree, this was one of the provisions that we agreed to last meeting. So I don't want to be redundant or backing up, but I just want to know like what changed from now and Thanksgiving that this became such a big deal.
I guess I reconsidered,
Okay.
if you wanna.
Why did you reconsider?
Well, I believe the statute speaks for itself, Mr. Williams. I mean, it's, I've never had a problem with this 107 being an issue.
So I will tell you that that's not true, that this
I
statute,
said, I have never had a problem with it.
and that I wouldn't say that that's personal to you, but this issue has been litigated multiple times by multiple other cities, and so it obviously is a problem. And the language that we're proposing isn't unusual language, it's in other contracts that's been used to resolve said problems. If it was never a contractual issue, there would be no lawsuits that exist as it relates to this issue. So I think that that's important to know going in. I think it's also important to know that without some type of clarification on what's expected in the language and relying solely on the statute, you open yourself up to potential litigation in a situation where, again, where you said they missed their deadline and they didn't have to negotiate. Again, the city manager obviously at that time wanted to do that. That's not always going to happen, and hasn't happened in other situations for other cities, which does what creates a situation where a lawsuit has to be produced. So obviously that's not good for either party, and all we're asking to do is to clarify additional issues so that we can avoid potential issues in the future.
Yeah, and this is, you know, standard for contracts. I get things all day, certified letters to notification that does something for the city. But it's just, we're just trying to clarify and come up with a practical way of notification. No matter who the city manager, we get tons of emails all day, tons of emails. And then there's no guarantee that it's even gonna get to where it was intended to get to, or it could be in a spam file, it just doesn't get there. I think this offers more surety that the notification will be delivered and we can move forward in an expeditious manner rather than saying, well, I sent an email and, well, somebody saying, well, I didn't see the email. You will have a record, you have a receipt that you sent it, and with that certified letter that it was gone and it was there. I just think it clarifies the process, it sharpens the process, and we both have records of what happened. Rather than an email, electronic communication that might or might not get where it's intended. Okay,
Are there any other changes?
Well, we'll caucus on this one. I think Cody has a question.
Has this been a problem in Beaumont? You talked about cases and other places.
Again, this
Have
was
we had an
more,
issue here?
it was more about the city manager's preference in receiving
No,
notice.
I mean, I'm not talking about the certified letter. We can
Obviously, it's a
give or
problem.
take. We're indifferent towards that. I'm talking about the specific language for the monetary compensation. Has that been a problem? Because
Again,
we're
I
not
think
aware of it.
I think he's just asking for notice. If you want to be fully transparent, I've been with the city 14 years. I've never seen a letter from the fire union requesting negotiations, so I don't know how it occurred. I know when police sends their notice, it is in the form of a certified letter, and it does outline what they're requesting and what they want to negotiate for.
Specifically.
It specifically says that they are looking for an increase in wages and they're looking for X. It doesn't always say that their last notice was similar to that, but it always says that they want these things. It kind of outlines their negotiations.
I only ask if it's been an issue here, because if we're not aware that it's an issue, then nobody's ever brought it up. If it was a problem, then why not bring it up and talk about it?
I've been here, we did bring it up. I've been here 14 years. I've
No,
never
you
seen
brought
it.
it up in here. I'm talking about, this is a problem.
This is when you
for
bring
you
it
to
up.
want to add language to the contract. So I'm just wondering, when did this become a problem, and why didn't we just talk about it whenever it?
But this is when you bring it up. You bring up,
You can have a conversation outside of a contract negotiation.
no.
My point is, we
can't.
sent an email or emails a very long time ago. If there was some question about whether there was, an intent to bargain over monetary compensation or whatever, why not just ask?
I did. I asked what you wanted during the discussion.
Well, you asked what we wanted to propose. We're not going to talk about that, but
Yeah, okay. Well, it was brought up and you said you couldn't talk about it.
okay.
Well, we'll discuss this in our caucus.
And I did put that in writing, Cody. All right. Well, okay.
Go ahead, Jeff.
Mr. Williams, I remember whenever it was brought up, and as I discussed with you that day when it was brought up, we weren't interested in bargaining outside of this bargaining unit. So asking me for a proposal before we came here, I believe was not the correct way to handle this. We sent multiple intents to bargain over the last year with responses that something would be set up soon. And then here we are a year later, waiting until after the contract has expired to negotiate. I just want to make it clear for the record that we did have this discussion. And as I said, we're not going to give a proposal prior to a formal meeting. We can let you know that it's time to bargain, but other than that, we don't see the point.
But you were the one that said you just wanted to talk about it, and we tried to talk about it before this. So I was just responding to that.
Sir, in my first email, I notified the city that we had extensive issues to talk about, that we needed to work out, that we believed were going to take a long time. We were ready to give you a proposal whenever we sat down for the initial meeting.
And that's why I'm asking for a certified letter, so we all have records of that.
And the fact that we're having this discussion illustrates the point that Sheree was trying to make. It's obviously been an issue. This is not just duplicative, unnecessary language.
But more importantly, the language doesn't require a proposal. It just specifically says if you're going to, like you said, your letter said you want to discuss multiple issues. It's not harmful to put that you want to discuss cleaning up the contract language and an increase in wages. That's not a big ask.
So for example, in the certified letter, if it says, we want to discuss an increase in monetary compensation, period.
So in Jeff's email that he sent, had he just taken that same email and put it in a certified document and said that the union would like to commence negotiations to discuss an increase in monetary wages and other contractual issues, fine. That's not a proposal.
But by the same token, couldn't a phone call be made and said, hey, send me a certified letter?
Well, it sounds like there were conversations attempting to get everybody on the same page and it wasn't happening. So the bottom line is the city is insisting that there is a more formalized process so that everybody understands how the initiations are going to be commenced. And we don't have to, neither the union nor the city later on has to get into a debate about whether 107 was satisfied. Let's do it here. We're here. We're discussing all of these other issues. This is an important topic and obviously one that here has been kind of a sticky issue before. So let's fix it and move on. I think that's the bottom line here.
So the issue is the certified letter.
I think that's part of the issue, the certified letter, which I think helps clarify notification. And then there's the issue of the notice of increase in compensation.
Well, the notice, if you give a notice, that means that you want to talk about anything that the city needs to appropriate monetarily. It's already in the statute.
Again, the statute is saying that you have to give written notice, and you're saying we could just pick up the phone and say, hey, send us a certified letter. Again, the statute is very broad.
I used an example saying, wouldn't that have solved the problem, Mr. Williams? If you had wanted a certified letter, you could have made a phone call and asked Jeff, can you send me a certified letter?
That's not a requirement under the statute. Mr.
know.
Newsom could have said no. If it's a requirement of the contract, he has to comply with that.
I don't think he would have said no. Would you have said no, Jeff?
I think that's irrelevant at this point.
I mean,
Yeah, and I think that's kind of making my point, you know, we gotta make a phone call, we gotta notify somebody to send something. I think if, you know,
I think,
Jeff, they've been at this a long time. If whoever's in that place now, in the future, or in this city manager spot, if it's clearly defined in the contract how that notification is gonna take place, nobody have to guess about sending emails or picking up a phone call, any of that, and you'll get clear, precise communication on how that's to get started, and it goes from there.
So to clarify the certified letter, the union shall provide a formal notice of, the form of a certified letter to the city manager, period. That would be something we would consider. Because sending the notice implies that you're gonna ask for monetary, anything that requires an appropriation from the governing body. Unless I'm reading it wrong. If you want the certified letter language in the contract, then we will consider it.
Okay, just to be clear on this record, if the city agrees that, to strike the additional language about monetary compensation, we want to be clear that if the written notice sent by certified mail is not compliant with 107, negotiations do not begin, and if they blow the 120 deadline, then the contract lapses and we go back to 143. Just so everybody is on the same page about that.
Yeah, I mean, that's understood. I mean,
Okay,
I don't think it is. I don't think it
I'm
is.
not sure it is, but.
I don't think it is
okay.
understood because again, it's been litigated. It's been litigated before, so it's not an understanding. And I think saying that just because it hasn't happened here doesn't mean it can't happen here.
True.
And I started the conversation with negotiations and saying that the idea is not to fix the contract for issues that exist. It's to fix the contract for issues that exist that could possibly arise and the future problems down the line. You don't write a contract for what's happening right now. I think that that's part of the problem. You write a contract for where you're going, not for where you are.
but you can't predict the future.
You can't, which is why
We're here now.
which is why you plan it.
Obviously, there's not a very good labor management relationship. I mean, these are just my observations. They're not accusations. And if we're arguing about this, I mean, I've never had this discussion before with anywhere else I've bargained. Like I said, we consider adding the language about the certified letter.
Okay. And actually, this is more forgiving than what's in 174 for the union, but that's fine.
How so?
Well, yeah, I mean, you can read 107 and there's additional obligations beyond just the notification regarding monetary compensation. So if the union wants to be encumbered by having to predict whether their proposals are going to require monetary appropriation, then so be it. We'll go back to 174 and do the certified letter.
Well, usually.
This is actually a little bit easier on the union to satisfy their obligation, but if they want to give that up and just default to 174 and agree to the certified letter, then
I
fine.
don't think we're giving anything up. I mean, it's statutory,
I know, but the statute actually requires something addition.
120 days before the end of the fiscal year.
And what I'm saying is, it's not just monetary compensation under 174. There's an additional obligation that yes, the union already has to do that. So why we're even having this conversation, I think is
Me
kind of
too.
silly.
I don't believe it myself.
But this, there is an additional requirement under 107 that
Which is?
this wouldn't be requiring of the union. So if they want to waive and default and just do what 107 requires and do a certified letter, then I think we can talk about it and we can probably get there, but it seems like a silly thing for the union to argue over when they're actually having a benefit here that's.
I don't see the benefit.
Okay.
What is the benefit?
Well, look at 107 and
Okay.
compare the
Looking
two.
at 107, if compensation or another matter that requires an appropriation of money by any governing body is included for collective bargaining under this chapter, an association shall serve on the public employer a written notice of its request for collective bargaining at least 120 days before the date on which the public employer's current fiscal operating budget ends.
Right. That's just monetary compensation, what we proposed. What you just read adds to that. But I think we're past that. Let's move on. We'll consider having the union do all of the things that 107 requires anyway, and we would just ask for the certified letter to keep everybody on the same page.
Sure. Let's move on then.
And the only other item was the addition of the assistant chief to the wage table. Okay, so we will remove Article 2 and the recognition and the notice to commence from the TA agreements and then get those scheduled for sign. We need about 15 minutes to do that.
Okay. Did you need to take a break? Yeah, I think we need to take a break. Yes. Take 15, sir. Thank you.
We'll take a 15-minute break and commence at 9:55. Okay, we'll reconvene at this point at 9:52 PM. AM, but there was a lot of Thanksgiving there. So, do you have anything for us?
So on the TAs, we removed the recognition and the notice to commence. So it's just the other ones that we discussed with the language that was proposed
Okay.
and presented. Oh, she has it. I just gave it to you so you can do it. So in response to the notice to commence, the city is willing to compromise and say that in section 2, sorry, I didn't realize it wasn't on my screen. The city is willing to compromise and say that the union shall provide a formal notice in the form of a certified letter in full compliance of Chapter 174 to the city manager, period.
Sure, that'll work. Thank you.
And we'll have this one prepared for TA before we leave today.
Okay. Let me write that down. Okay, thank you.
Okay, are there any other articles we need to go over?
Well, no, I think the next thing on the agenda was the union's presentation on union business, because I don't think that we're prepared to discuss the recognition one unless you guys had a chance to caucus on that. The language as proposed? Okay, we'll have those prepared.
Language as proposed.
We'll have those prepared to TA after lunch.
Okay.
And like I said, the next thing was for us to discuss the definitions prepared by the union.
Thank you.
No.
We went through the agreement and, I mean, that's all that we identified as needing a definition unless, I mean, we can look at this as a draft.
Are you gonna like walk us through it? I mean, just because it is recording and people are watching, so.
Sure, Cody, can you walk us through it?
Do you want me to read each one? I don't,
Again, there are people watching, so again, these are just, we're defining
right, okay.
agreement employer, the purpose for 40-hour versus 48-hour employee.
Right. So agreement and employer are just standard definitions. 40-hour versus 48-hour. There's mention of that later in the contract. I think we can get to that.
Okay.
And if, if we find that we don't need that, we can always remove it. Grievance is just another standard definition. Of course, internal union business was one of them specifically. To my knowledge, I think it was the only one that y'all specifically wanted a definition to. So that may clear up that union business article. And then union, again, just kind of a normal or typical.
So the only thing I would say about the union internal using business is that in practice, you can't use a word in your definition that you're defining. So we didn't really talk about what internal, like internal. So you use internal interest to the union. I'm assuming you mean sole benefit to the union?
Sure, yeah,
Okay.
yeah. I think, yeah, I can change that.
Okay. So for grievance, also an employee can file if they have like general complaints, not necessarily subject to a dispute regarding violations just of employment necessarily, right? Or are we just limiting now grievances to interpretation, application of the alleged?
No, I agree with you. Maybe that wasn't the best wording,
Okay.
but I can,
We can wordsmith it a little more. I mean, a grievance is usually a perceived violation of the contract.
Right.
And there's a formal process to dispense with that or address it. I mean, there's a difference between a complaint and an actual grievance.
Right.
A complaint is a complaint.
Right. It just goes
It
back to
has to be pointed to.
it goes back to the general principle of kind of using words that define other words in your definition. I'm just trying to clarify because once we adopt it, these become the situation. So when we go to arbitration or something happens, this also becomes what they're looking at, and it becomes an issue of contention as to what the parties meant and what's agreed upon. So I want to make sure that we're not limiting the rights of the membership by offering a definitions table.
right, agreed. If y'all don't mind, that one's not holding anything up. If you could just give us a chance to work on that wording just a little bit more, we'll bring something back later
Okay.
on.
And then for the, I guess we were kind of the sole,
Any activity that is of sole benefit.
what would you consider a mutual interest? Just in theory, I know that there's been several meetings between the union, the city manager, and the fire chief. I would consider those in trying to handle problems. Those would be mutual interests. So would the union now be union members be seeking compensation for that?
Really, anything can be considered a mutual interest. I mean,
I know that's what I'm
internal would
asking.
be the meeting, scheduling the meeting, chairing the union meeting. I mean, that's not anything having to do with the city. That's an internal union process. Election of officers, election of delegates to convention. I mean, pretty much everything can be of mutual interest to both parties. I mean, if you're looking to work well together,
I know,
You
so,
know?
which is why I'm asking, because, again, and the city doesn't pay for internal union business. We separate that, and it's not allowed to be done on city time. So anything, again, my question was, would you consider those meetings now of mutual interest? Or as Mr. Tez defined, there are several other things that can be defined as sole interest of the union, and anything outside of that can be defined as an interest, a mutual interest to both parties.
We're not looking to gain anything more than what we've done in the past. You know, like those meetings that they had were done off duty. Could they be done on duty? Sure. I mean, I think they've been done on duty before. But mutual interest would be, you know, anything that has an effect on the employer and the union. So like you just gave an example, when we have elections for officers, we've been allowed to be released from duty for that before. If the city doesn't want to allow us to do that, that is internal business.
How do y'all normally vote for union? Do y'all do that as a union, or are those meetings held like on shift?
We have,
hold on, don't answer. No, not really.
No, I mean, if this is not a trick question, I'm asking, like, do you send out a poll? Do y'all vote electronically? Do y'all have to vote in person? I don't know what the bylaws say.
no, we have, our bylaws state that we have nominations in our January meeting, and then if there's a contested race, then we have an election at the end of that month. So
Okay.
it's a multiple day
We're
election.
bound by Department of Labor law. You know, we've had, I guess, litigation involving elections and representations of such. So we've got to also adhere to some of those requirements by the Department of Labor as far as notification of the election, ensuring a secret ballot, ensuring that everybody,
Oh, okay.
you know, those are internal mechanisms
Okay.
within our organization that we're required to comply with in order to have, I guess, an election that withstands any challenges, so to speak.
Excuse my ignorance. I was asking specifically for, like, what would be the purpose that you would need to be released from duty for elections?
I have specifically before, because I'm the elections committee chair. So,
So you have to oversee it.
right, yeah.
Okay.
But again, I think there's give and take available here. I don't think that we've, attempted to abuse that union business in the past. Have I been released, for that purpose before? Yes. I don't have to be, like I said, we're trying our best to define this so that we can get past it, but we're not overly concerned with, I don't know. I mean, do you see any issue with the
No,
definition?
for me, I just want to make sure that we're clear so that we know it. If we chose to adopt the definitions as written, the city understands like what that assumption means, that it's clearly communicated to what the responsibilities of the department, the chief or whatever moving forward, because would be further defining a benefit that the union has and is entitled to, right? So I think that's what my clarification question was, is like making sure that we're clear on what the expectations were so that there isn't future confusion on that.
Right.
I think that,
I'd just say, as an example of just further explanation of what he's talking about, as far as being an election chair committee and Department of Labor rules for us, the way we handle our elections, we hold 3-day elections. So to allow all of our members to be able to go there, I generally appoint Cody as an election chair, so he's in charge overseeing all of that. We've never had to request multiple people to be off to do that, but in keeping, up with that process to make sure that the process is followed. That's why he's been able to attend those in the past.
and so the 3 days is for the 3 different shifts,
Yes.
and they vote at the union?
Yeah, that allows for our members to be able to show up the morning that they get off from work to be able to show up in attendance to vote in person.
Okay, and so y'all do in-person voting at the Union Hall?
Yes, ma'am, it has to be in person.
Okay. Okay. Are there any? I'd like to discuss it internally, unless you have some questions.
I just want to make sure I'm understanding. So is the idea can you scroll up a little there? If it's business that is of mutual interest, then it can be done on duty? Is that?
I mean, it would depend on, getting permission, I guess. I mean, I don't know if the big issue is no union business on duty. Is that the issue that we're trying to?
I don't know that there is an
address?
issue. I'm just asking because it's this, I know that when we talked about the union business article, defining what that was kind of where the snag.
Yeah,
Right, so I'm trying to figure out if this is intended to suggest that if it's of sole interest to the union, then it has to be off-duty. But if there's union business that's of a mix, sort of could potentially be of interest to the city as well, then it's expected to be able to be done on duty.
I mean, we struggled with this as well. I mean, there's 1,000 different ways to address this thing. I guess the key word was internal union business. I mean, internal union business were those examples I gave you of, the stuff that we do over here that doesn't involve, any collaboration with the city, so to speak. Like, the meetings, the mundane work of our administrative requirements in the bylaws and through the international association. I mean, we were ourselves trying to figure out, how do we define this thing? I mean, what
Sure.
are we trying to accomplish, I guess, is a good question.
So I guess in terms of accomplishment, one, we wanted to clarify some of the things, I guess, when we were going back and forth, there was some discussion. I think definitions you proposed was intended to kind of clear up the contract to make sure that we were clear. I think my biggest hangup is that, again, I don't want to create more confusion in our contract.
do I.
So mutual interest to the employer, again, that takes it out of the internal. And so when an employee does something, on the clock, they're paid for it, right? So they're compensated for that interest. We don't want to get into a situation where that's not happening. So if we're offering a benefit or agreeing to a benefit, we want to make it clear what that benefit is so that there's not a disconnect on what happens. Currently in the contract, it says that, that's done not on city time. So if we're now going to kind of augment that, we need to be clear on what the mutual interest things are, and also kind of outlining what's considered internal. Because like you said, there's a laundry list of things that can be internal, but there's also some times where there's some overlap, and they can be considered, beneficial to both parties. I think training is always kind of mutual interest of both parties, but if it's solely the benefit of making them better, we can say, hey, that's over there, but it could potentially be a mutual benefit. I think internal discussions between parties, serve both people, but
Sure.
how do you, is that union business is not? So I think that the idea is that to offer clarity and not to kind of more muddy the contract.
True. I don't know. We were in the impression that this was something that needed to be defined.
Yeah.
I mean, the current language in the contract states that union business not be done on city time. And I don't think that's been an issue. I mean, it's current language, so I mean, if we want to leave that alone, that's fine. I mean, if we don't need this definition, then we could talk about that.
Well, I think the definition was proposed just because the city offered some clarification language. And when you asked like why, we just said we wanted to make sure what was clear, what was union business and what wasn't.
I mean, we could go laundry list of both. I mean, you know?
Again, I don't want to make it more complicated.
Me either.
I think
Believe me.
we want to streamline it as much as
Yes.
possible, but I also think that we want to make sure that if we're offering additional benefits, that's clear what those benefits are.
I mean, in theory, I had a chief that said every firefighter, that, I'm using old school language, is a half union member, half city employee. I mean, you can't really separate the two then. And, usually the chief comes through the ranks as well. Unfortunately, when he becomes the fire chief, the law does not allow us to represent him. I mean, that's in statute. I mean, everybody knows that, but I mean, how do we define that? I mean, without adding 500 pages to the contract? I don't know. I mean, we can leave it for discussion, percolate on it some more.
Yeah, I think we're gonna have a counter proposal that'll delineate at least some examples of the, what would be sole interest or union business. But I guess my question was more about the flip of that, not what's internal, but I'm asking just squarely, is the union asking to be able to do mixed business on duty? Is that what this is trying to accomplish? Because that's how I read it. So if I'm reading more into it than is intended, that's what I'm trying to get to the bottom of.
What do you mean by mixed business? Just so I'm clear.
Something that's of mutual interest.
Using the mutual interest card to cover everything.
Right.
That's an example, an extreme example, of course, but
I'm not suggesting that that's what's intended. I'm saying, is this additional language about mutual interest so that the union has flexibility to say, we get to do this on duty because it's going to be of interest to the city as well as that's what I'm asking.
I can, off the top of my head, one example, we have many members that come to us on a daily basis that may have complaints, but they go to their union stewards whenever they're at work. We have a union steward assigned to each shift. Making sure that those members are able to consult with an issue to determine whether or not there's a mutual agreement violation or so on and so forth. We get those all the time. More times than not, they're not real issues, and we're able to stop that before it gets to the chain of command, before it goes up to the chief, by being able to consult with our members while they're there. They generally reach out to us first whenever they feel like something may be wrong. So that happens on a daily basis, and we're just able to consult with them to determine.
most of the time it's a complaint. Member thinks it's a grievance. At that point, it gets handled. Educated, this is not a grievance. There's nothing in the agreement that specifies what you're upset about. This sounds like a complaint, and kind of educate and help that member, employee, however you want to call it, resolve their issue. A lot of HR stuff, in other
Yeah.
words.
So I understand that part of it. And then the second piece is the union saying that they should be on duty when that happens because it's of a benefit, kind of cut something off before it goes any farther and it's a benefit to the city?
We're not saying that it should be required to be. We're just saying that it should be allowed, that no one should get in trouble because a member spoke to their steward about an issue, and that we took the opportunity to show them in the contract where they may be right or they may be wrong, but just to give advice to our members while they're at work.
Has that been an issue?
Yes, it's absolutely. Like I said before, we receive a bunch of complaints that don't ever see it to you guys. It gives us opportunity
No, I
to
mean, like,
resolve
them
issues at
getting
a
in
lower
trouble.
level.
No, I mean, like someone talking to their union steward and getting in trouble. Has that been an issue? Because I'm assuming that's been a common practice
I
for a
don't-
long time.
Again, we're just trying to define the issue. I mean, I
It hasn't been an issue yet, I guess. I don't know. No one's gotten in trouble yet. But I mean,
How long have y'all had?
struggled with this, like I
Yeah.
said.
But union stewards have been in practice for quite some time, right? Okay. I think the city would like an opportunity, I guess, to counter or at least suggest some additional or
We
some
can
cleanup
discuss
language.
this.
So it's,
I gotta add something.
yeah,
You asked about us doing union business on duty. I don't think we typically do union business on duty. We're released from duty sometimes for particular purposes, and I think that's outlined in the same article.
Right.
But the only union-related business that I can think of is for years, I mean, until recently, union orientation was done on duty. That was the way it was when I hired in. And I can't think of anything else. We have a mentorship program for our new members, and we've done that orientation on duty before. And we have a peer support team, and some of that has been done on duty. So those are union-related functions that are done on duty.
But they're
But
also
again, they're
of mutual interest.
of mutual interest to, to the city and the union and MDA. He said MDA, I know you heard him. But typically, we're not on duty when we do union business anyway, so I don't.
Okay.
If it's not an issue, I mean, then we don't need to clutter up
I think,
anymore.
again, I think this came up because we proposed in the contract to add, I think the contract already said internal, and I think we proposed regular business. And I think that's where the conversation about definitions came into play, about what that looks like based on some of the language that we had proposed. I don't think it's a question as to whether or not, like some of the programs existing, I don't think that those are fine, but I think that there were some other issues about whether or not when the union, as you said, when union business starts and when it's solely union versus employer business, just, for purposes of the negotiations, like, I know that no one in this room is on duty right now.
I am.
Well, yeah, not on my ticket, not on my ticket. But all of the employees had to, the fire department had to request off to be here, or they're on vacation or whatever time. So, but I would consider this meeting a mutual interest,
True.
right? So, but the language says that our contract says only 2 members can be off for union business at a time. So everybody else had to either be off or request, they couldn't request off. They had to either be off or trade time or go through some things. So the definition in and of itself changes some other language in the contract that we'd obviously, if agreed to, would have to finagle, and it also creates a financial benefit potentially for some of the members. So those are some other things that we have to consider and move around. So we just want to be clear on, again, what's being asked, what's being clarified.
I guess we threw it on the table and we can figure it out. I mean, we can discuss and, this is what negotiations are all about, putting something on the table and then trying to figure out how to resolve this issue or other issues.
I think this one might make the most sense to revisit when we get to the union business article. So we're talking about it in context, because I think I'm maybe going off somewhere that's not.
Well, it's easy to do. Like I said, we struggled. How do you define that?
Yeah.
And we know, it's common practice that union business is not done on duty. There's things that happen of mutual interest on a daily basis that I guess we can't identify or put into an agreement with examples without expanding the agreement into a 500-page document, and I'm exaggerating a little bit, but we want, like Ms. Reed said, we want to keep this simple and not muddy up things to where, it's a workable document and it's streamlined and, we know what it says and.
Okay, then, in light of that, I think it just makes sense to, we're gonna have, I think, some proposed definitions as well.
I
And we
guess
can.
what threw me off was the internal, that's what I focused on and that's how we put this together. So we can revisit this.
Yeah, I think so. Internal was, I guess, a term of art that was already in the contract, and then the city proposed regular. And I think that kind of,
just as a point of information, I've seen things in this contract that are unique that I haven't seen before.
Because we're special.
Haven't been to Beaumont. Thanks for
Unique.
coming, Joe.
How's unique? You're unique.
Yeah.
That's you.
You can kind of see this was the last, the cities, I guess, changes were in purple. The union's changes are in blue. And so,
Could you make that just a little bit bigger,
sure.
please? Okay.
Is that good?
Yes, that's good. Thank you.
Okay. Yeah, so the city changes were in purple, the union changes were in blue. This is, I guess, where we had the biggest conversation. The city had added this language. This includes, was not limited to regular and special union meetings, meetings with attorneys, arbitration preparation, arbitrations, court hearings, or trial, and any union business not specifically stated in Article 2 of this article, Section 2 of this article, and that was stricken.
You have a question? Go ahead.
And so we put, again, we'd added some other, like, I guess, like clarification to what that looks like. And so I think that that's where the conversation started.
Just a question for clarification. Is that language that you added in that section for the purpose of us not doing those things on duty or not being released from duty for those things?
So right now, it just says in Section 4, it says no more than 2 members. And so we clarified that as well. So it would allow you to do it, just not on city time. It doesn't have any restrictions on release of duty, just
Right.
other than no more than 2.
Right, that's why I asked, because there's allowances for us to be released from duty for union business as it is, and I think that's typically gone well in the past. But if you're I guess that's what I'm trying to clarify is, special union meetings, meetings with attorneys, arbitration, those things. Are you just saying that those shouldn't be done while we're at work?
Yeah, it just says it shall not be conducted during the, shall be conducted during the non-duty hours. So not on work time.
So the intent is to not release us from duty for those
So if you,
purposes?
but I guess if you can, I guess like right now, y'all have a request to be off, right? How does that work?
We just, if we need to be off for union business, we send an email to the fire chief requesting to be off.
And he grants that, is there a time where he wouldn't grant that?
I think that we've agreed on making sure that it's ahead of the start of the shift. That was something that we talked about a while back, and we've started ensuring that we get that request in, ahead of the start of the shift. Typically, we try to give as much lead time as possible for, to not make create a scheduling problem. But
Yeah, so I don't think that this would change that process, because you would still be, like when you're released from duty, you're not at work, right?
Right.
Yeah, so I
So
don't think,
those things would be done during non-duty hours because
Yeah.
we're not on duty.
right, so I don't think that that's a problem.
Okay,
But
I just
I
wanted
just
to
know
make
that's
sure.
that's where the conversation started, was with this section and those amendments.
Right. I just wanted to make sure I completely understood the intent behind it. That's all.
Yeah, I think the city was trying to make clear those types of activities have to be done off-duty. And then since the union proposed to strike those specific activities, I think we had asked them, tell us what it is the internal business is going to be. And I don't know that we've advanced the ball a whole lot in terms of getting everybody to understand this has to be done off duty, or this has to be done when you're released, or this can be done on duty. Those seem to be the three categories, and it just,
That's where my question comes from is,
Right, I hear- yeah.
do you mean I was never supposed to be at work
scheduled
today?
in the first place, right?
Or am I off duty because I was released from duty?
And see, I don't know that the current process is a problem. Like if there's an understanding that you make that request off duty or before the shift starts, I think that that's fine, and we need to clarify that we can. But I think it was just more about identifying or attempting to identify what union business. So like obviously if we remove this language here, then we would want to incorporate it in some way, incorporate it into the definition so that it's clear these are things that we've identified as potential union business. And I think there's some other ones up here that are kind of defined as well.
Are there things that you guys that specifically don't want to allow us to be released for?
And I think you can take off for whatever you want to take off for. I think it's a conversation about not being allowed to do it. Like,
While at work?
yeah, so like right now, somebody couldn't pull up their fire truck and say, hey, I wanted to see it in person. So
Gotcha.
we don't have a call right now, so we're just going to sit in the back and watch.
Okay,
You see what I'm saying? So like, or, you know, it's a slow day at the station. Just gonna walk on down to City
Right.
Hall. I think it's one of those things. So if it's clear, again, this is, you know, I don't know what this would count for them. It's a mutual interest, right? But they're on duty, so like I said,
gotcha.
everybody here participating is all for the union side at least is off duty. But if somebody in a uniform kind of popped up, that would probably be inappropriate.
I think
The language that was stricken was the city language?
So the language in purple was the city's language. The changes in blue, I already had Cody's flash drive in, so I just went with his document because it already had both changes reflected. So that's why the strikeouts are there. I can turn off or reject the changes, and you can kind of see them, but I don't know if that'll erase his changes, so I don't want to do
That's
that.
fine, you don't have to do that.
Okay.
On the language that's stricken on arbitrations,
I
just a
can't.
question.
Where-
I have that section 4 or 5, something like that.
Section
5?
5.
The city has witnesses and the union has witnesses, an arbitrator would call somebody that's on duty. According to this, they would not be allowed to attend?
So typically, we have allowed individuals who are on duty to attend, and we've put them out of service for that, and they just have to return back if there's been prior notice of them. So we don't make them take off, but for them to just again show up to watch arbitration, and we can
No, no, I mean, that's understood.
clarify that. But also just in general, we also don't release them from duty to meet. So if they're a witness and they've been on the witness list or complaint, they don't have to. And they're on duty. If the complaining is their arbitration, yeah, they need to be off. But if they're a witness to the arbitration,
You get subpoenaed, you gotta show up, right? I think. But I'm just a question,
you can listen to it. It's open for. That's what I'm saying. Like this language was put in there to kind of clarify what that looks like. Obviously, we can pull it out in a stronger definition section so that we can keep that section clear. But I can see your point on arbitrations.
yeah, or court hearings, if you're subpoenaed and you're on duty.
Well, so yeah, if you're testifying in a court, yeah, that's a thing. But if you're arrested, then no.
Arrested. If you're arrested, you probably don't work here anymore.
Well, I don't know. Due process and all
Right,
that.
Chief?
Due process and all that jazz.
Yes, the wheels of justice turn
Yeah.
slowly.
Due
as
process.
we
But I'm
know.
just like, so it's intended, basically, it's just one of those things where, you can't pull your fire truck up to City Hall, to municipal court to pay your
that
traffic
should be
ticket.
common sense.
Yeah, so I think we can, there's a way to kind of clarify those type of things, but again, you can't, it's intended for not to be, someone just wants to show support for a union member who's participating in a court hearing. They'd have to do that off duty as opposed to doing it
Correct.
on duty.
I think we try and educate our members of such
Yeah, so something, I think
practices.
there's some room for clarification in some of that. And like I said, we can probably get that cleaned up in the definition. So I'm not too,
Yeah, our
I'm
concern
not
was that
heartbroken over that. I just wanted to clarify, like, this is where it started.
our concern was, were you trying to limit our ability to take time off for, as it's currently done?
No, so I guess the intent was to clarify what the city saw as internal or regular business, not necessarily to limit what you have the ability to request off for. But we can, like I said, I'm fine with taking that language out and just having a more clarified definition section for not necessarily internal union business, but just what union business looks like. And then we can, I guess if we need to define internal, we can. Because I think in section 2, they break down what is, kind of what they should be granted off to. They took out civil service meetings and just put meetings. I think that would probably need to be open for interpretation because anything and everything can kind of be a meeting. So we might need to just leave civil service meetings in there and add additional meetings if that's necessary. But I think what it's intended to do is not allow everyone off.
No, correct. That's understood.
Right. I think if we can just talk about that at our next caucus.
Yeah, that's fine. I think we're getting close
That
to
clarification
Yeah, I
was
think we're getting
helpful.
close to something. So when we separate, like I said, we'll try to come back with a reasonable count on definitions after lunch. And I think that, like I said, it started with kind of this section 5 about that. Now we did want to, I guess, make sure, because it says here in section 4 that it kind of just became no more than 2 people off a negotiating team, but that was never clarified as it relates to other union things. So we wanted to kind of put that in there. If there's a different or more reasonable number.
Okay, I do have something on that, and we talked about this, and I didn't put it in there. We can discuss it if you want.
Yeah.
That number 2, there's 3 of us on each side. In the future, if we don't have an outside representative come in, then we would have 3 of us here, and if the 3 members of the negotiating team happen to end up being on the same shift, and that 2 in there would potentially cause a problem. Specifically to these meetings, we don't have that many meetings, and not all of them are all day. So maybe just changing that number 2 to 3.
Just in section 4, because we proposed.
Right, just in section 4, just so the likelihood of it happening, I don't know, but at least it takes that problem away in the future, because there are 3 people on each bargaining team. Not something we're stuck on, but since we're on the article, we're talking about it and figured I'd bring it up.
And so, again, we proposed, and I just pulled a number because we had the number 2 here in section 2, moving that throughout in section 6 as well. Can you, I guess, provide insight on how, if we increase that number to 3, or if there's another number that needs to be more comfortable?
Yeah, so the 2 in section 4 is specific to the contract negotiations, but in number 6, the only reason we struck that out is just that section isn't required. So, and what I mean by that is anybody any of our union officers that want to go to any kind of training or conferences, those sorts of things. There wasn't a limit on that before. Shoot, I got A and B swapped out of my mind. We struck that because we have 3 delegates. we have 3 delegates, not 2, and we have other board members that can be,
Oh, no,
Help me, I'm having
I'm
a
fine with
stroke. Alternates,
section
thank
4.
you.
I guess my question on section 6 is that if there's a conference or a seminar that's being hosted and several members want to check off, like, what would be the, like, I guess the recourse for the chief to deny that if there wasn't a number put on that? Because it's specific to officers and elected delegates.
Yeah, so at least 2 people could be, but the way we changed it was that any number of people above the 2 can request a go, and it would be up to the chief if he wanted to send 3, if he wanted to allow 3 off per shift or 4 off per shift, but that at least 2 would be able to attend that. And if manpower allowed, the chief wouldn't have his hands tied. He would be allowed to
Okay.
send more people if the schedule allowed.
So section 6 only applies to the officers and elected delegates, so you would be fine with 2 there? So it does, and like I said, it's only applying to the elected, it doesn't, I guess, apply to other members, but it's just the union officers and elected. So I'm asking, I guess, because that number 2 was stricken, says no more than 2, so if there's another number.
How many people are we talking about possibly total?
So you have the elected officers, and then there's a union steward per shift, right? So it's 5 elected, and then 3 union stewards, 8? Is that too many elected?
Turn it off. The entire board is elected. So we have 9 board members who are elected. So 9 officers right now currently. We have 1 vacant position right now, our EMS steward. So generally we have 10 board members who are all elected.
You don't have any appointed positions?
Well, right now, appointed positions, yes, and they change on a frequent basis. They could, because that just comes from if I have a standing committee, I can appoint a chair to that. They're appointed officers at that time to chair certain committees. For example, I have a peer support chairman right now. I have a mentorship chairman right now. I have a safety committee chairman right now. I can go on
Okay.
and on, but
So those aren't-
but some of those get appointed, and we may swap members out if people leave. I mean, we have a lot of different committees. In other words,
Okay, so those aren't included in the elected delegates, it's just the officers, so that number would be 10,
I would consider them to be representatives of our local.
but not elected delegates? I'm sorry, would you consider them to be officers?
Well, they can be. We can put those members or appoint those members as delegates as well. So.
I'm just trying to stay with the language of the contract. It just says officers and elected delegates. I'm just trying to identify, like,
An
with those
elected
individuals.
delegate would be somebody that's elected by the membership to
Okay.
attend the International Biennial Convention.
Okay,
So we're bound by Department of Labor laws. You get 2 automatics, which is the president and the secretary treasurer as principal officers. And then the membership would have to agree to elect another delegate if they so choose. Plus, that means they're agreeing to absorb the cost of sending that delegate.
okay. So now we're getting to meat and potatoes.
Elected delegate means that you're
Okay.
elected by the membership to attend the convention.
Okay, so now we're getting to it. So, right, you're guaranteed to, and so my question, to attend those seminars by the president and the
For
designee.
convention are automatic delegates, and then everybody else is voted
Okay,
on. The membership can elect to send 10, but then they'd have to foot the bill for everybody they send, so to speak.
so my question then would be, like, what's a comfortable number for that section? Is it 3 also?
That's what I was going to say is we can't afford to send a bunch of people to these conferences anyway. So we're not typically talking about any more than, I think the most that we've ever sent is 5 or 6. That's typically conventions. The confusion with this particular section comes because this isn't just about conventions. So conventions have delegates, but our conferences and our seminars, some of our training classes, that's also roped into this section. So we're just trying not to limit our ability to send multiple of our union board to training and conferences and conventions if.
But this was, I guess, was specifically to that people. So I guess like other members could go in a different one. I guess we can probably clean up the language. This was existing. So I think it was probably more geared towards that, not necessarily preventing other members from going.
Right, the next section in B, that's where it talks about everybody else, other than officers and delegates.
Okay, yeah. So you want to change, you took out two.
Right,
So
yeah,
any number of
this was
members.
the one that I was originally talking about. That's why I said I got my wires crossed earlier.
So,
We just put any other number of members, so there's not a handcuff there, because it doesn't say he shall grant them to attend. It's,
so in section A, if we change the 2 to 3 to match section 4, and then in section B, if we just said in writing with so many days in advance, I don't know how much notice y'all have to register for conferences, but in so much notice of advance, we can allow any other number of members. But I think that you have to cap that because you don't want to have a day when there's nobody that shows up.
right, that's fine, we put that as if manpower permits and, we're able to send 3 or 4, we don't want to be handcuffed by contractual language that says only 2. Because it already says at the bottom, may be granted or denied by the fire chief anyway.
Yeah, I'm good with this one in section B. I'm good with the changes there. I guess my question was in A. So we can, I guess, I would like to leave in writing to the fire chief, but we can leave the other language as is. I would take out
I do have a
the other
question.
number of members.
Instead of any other numbers, just say chief to allow time
Yeah,
of members to
Yeah.
attend.
we would take this part out.
Yeah, because
Just-
ultimately
Yeah,
the
we would
chief
take this part out and only have the only language that would remain would be the in writing and fire chief to
Okay.
allow.
Yeah, it's pretty close to original language. Yeah.
My understanding, there's a total of 10 officers. That include union stewards and all that too. They are considered officers.
It does, as far as the union officers, the elected officers, again, just wanted to add the appointed committee chairs that we have. There's multiple of those, so that's where we don't want to limit, a peer support chairman from being able to attend peer support conferences and so on.
I think the issue though is because this would require the chief to give the time off. You're talking about potentially 10
No.
at a time.
I
On A?
think B clarifies that
Well,
the
no,
chief would,
Well, B is for the non-officers. B is for everybody else. So you potentially could have, what I'm hearing, or what I'm understanding from this discussion is you could potentially have up to 10, that's how many officers there are, that the chief would be required to allow off for a job-related conference at one time.
I guess it would be, I guess I agree with you that the potential could be there, but that is per shift. So
It doesn't
like
say
right now, we generally don't have that many people per shift that are being requested off. So if 10 people went to conference, but there was 2 on the A shift and 2 on the B shift, they're not technically all off at the same time. It's, the days get alternated. So having pretty reasonable to think that if we requested 10 members to be off from the C shift, that we wouldn't be able to handle that staffing wise. That could be an issue. But this is just a number, an overall number, but not per shift.
Per shift.
Or I mean, it is per.
Yeah, so we'd have to, I think if we're going to do that, we need to amend it to say per shift, because right now it doesn't say that in the agreement. And I think right now, all the members aren't on one particular shift, but stranger things could happen. A shift could, have a major takeover in the next couple of years. And then we have everybody on A shift taking off to go to conferences. So
So if it were 2 per shift, is that,
She was asking if it was 2 per shift.
on A, is that,
That's what it is currently, is two per shift
I think
right
that's a
now, is what-
practice.
Is what it is currently, is 2 per.
Two off at any one time.
Yes, 2 off at any one time.
Is that,
So it's not per shift.
If we were to add the per shift, then I would think that it would at least need to match the number for the bargaining unit. Because again, we have
because we changed that
three
to, yeah, we
delegates.
changed that to 3. That's why I was asking here. So technically, it doesn't say, there's nowhere in the contract that it says no more than 2 per shift. It always just says that language. So in section 6, I would change it. I'm proposing that we change it to 3, but put in the language per shift. That way, if you have other members that want to attend and they're not necessitating for that. I mean, I know sometimes y'all like work overtime and trade time for other people, so you work on different shifts, but it will just
So you're saying section 6A be
no more
three
than
per shift?
3 per shift.
Can we take 10 minutes?
It's almost lunchtime. No, I'm kidding. No, I'm kidding. No. Go ahead. No, go ahead.
Sure, take 10 minutes. Okay, we'll reconvene. And there's this.
So I think we have an understanding on B is that we'll just do, except in section A, the union will request in writing to the fire chief to allow time off for members to attend. So we'll take out this any other, for members to attend union or job-related seminars, which permission may be granted or denied by the fire chief. And on this one, on A, we're proposing no more than 3 union officers, just to kind of match the language that's in section 4.
No more than 3 per shift. Is that what you were saying?
No, we just said no more than 3.
Well, you said no more than 3 per shift.
Yeah, I was asking about that, but after our discussion, I think the city's proposal is 3.
Isn't that different than our past practice?
I guess we can talk about that one.
And so on the other ones,
I'm sorry.
Oh, sorry.
Just on that, so just to be clear, I think if we change it to just no more than 3, or if we said no more than 2, past practice has been that meant per shift. So that could potentially, if we didn't put that per shift in there, I mean, even though the past practice has been that, it could limit the number of people, because if we had 4 delegates, which we have for the IAFF convention, or our alternates that are able to go to those conventions and they're on separate shifts, we wouldn't be able to send that many at that point, because we bring alternates to those as well. But as long as we didn't go over that number per shift, it wouldn't be limiting to us.
How long is the average conference?
I would say 4 to 5 days.
Does that include,
Sometimes with travel, we have to leave the day before, come back the day after. So sometimes we're gone as many as 7 days,
so,
depending on where we go.
so maximum 7 days, or are we pushing it to closer to 8?
So at this time, I don't know
Just a-
if we've
just a-
ever
just
been
a
to
strong-
one. I'm just
Just a strong guesstimate. I can tell you my longest conference is about 7 days.
right. Same here.
Longest, that's a long one.
Yeah, the longest conference, and that
Right.
includes travel.
Right. It has, that's what would make it that long, is flights and such.
So it'd be fair to just say 7 days.
Yeah, that would be an average.
And y'all are on a 3-day cycle, 3
Right.
shift. Okay. And then in section 5, we're proposing that we just take out internal and regular and just do union business, and we'll propose a definition for that after lunch.
Okay.
And then everything else, I think we're fine. We were fine with the 5 days. I think we said 5 business days
Yes.
previously, and that was fine. Okay, I just have your old version, so I'm still working for it, but it's corrected on my page. So we'll I think it's important that we leave in civil service meetings, and I guess when we define union business, we can kind of clarify what that is. I don't like it being open-ended to any meeting, because I think that kind of changes the purpose of it, and also they can kind of leave whether or not we call it a civil service, hearing, but, those things can kind of change a little bit. So I do want to leave that language in, and like I said, we can propose a definition that may be workable for everybody and discuss that after lunch.
We could see your proposal after.
Okay. Before we go to lunch, is there anything else that we need to discuss? We're going to bring back the changes for the notice to commence and adopt the recognition clause after lunch.
Are you trying to say it's almost lunchtime?
It is for me.
Okay. Then happy to accommodate you.
So I think that we only have, we have, I guess, some counters that we're willing to discuss after lunch, or we can kind of go through them. I don't know that we can go through them now, if you want to do that.
Good breaking time, and then we can. Well, you sent over a list of articles to discuss. Why don't we identify those and
Yeah.
confirm that I got them right?
Yeah, we can, but also like the union had provided, I guess, counters to overtime, hours and overtime, the department and committees, and then temporary promotions. We kind of addressed the ones in the union business. I guess I just want to make sure that once we break, that we have enough to discuss so that we don't have to take another break before lunch, keeping in mind that I am starving, so that's not my proposed.
Real quick, Article 4, you wanted
This
to
is a
discuss?
brunch person rather than a lunch person.
No, I agree.
I eat lunch later than 11:15.
Yes. Normal firefighter lunch is 11 o'clock.
I could have been a firefighter.
Yes. Just real quick, just to run out, it's Article 4, management rights.
Yes,
Article 6, union business, which we're kind of talking about right now.
yes,
Article 10, committees.
yes,
13, vacation holidays.
yes.
17, educational incentive pay. 18, education pay. 26, temporary promotions. And 29, wages, just the language.
Yes. So I think what we had today was, like I said, we're prepared to kind of talk over and through the ones that the union presented counters to at the last meeting. We can do that right now because the city has those ready to go. Like we already discussed union business, so the next one would be department committees. And on this one, I think it may be one that we want to hold until after we have a strong definition for union business, just because the union did propose some additional compensation for members that participate on those committees.
Okay.
And so I guess once we have a strong definition of what union business is, that may or may not impact the city's counter to that, if that's okay. There was, I guess, a concern that was raised as it relates to, hold on, give me a second to pull it up.
Sure.
Okay, so this one deals with the department and committees, and we had proposed that it be chaired by an assistant chief, and I think the union has taken that part out with the understanding that they didn't want the union chief or the assistant chief to have an extra vote. So I pulled the committee reports from the safety meeting, and there hasn't been a vote in that committee for over a year. So I don't think that that's that should be a concern. If that's the reason for the change, then that's not a necessary concern just because that committee doesn't vote.
To my knowledge, there has been votes in the past, whether it's happened in the past year or not. It's kind of, a little bit irrelevant because like you said, some of what we're doing here is looking at the future and not just now or in the past. So
So it's my understanding that
it needs to be a vote.
the purpose of the committee isn't to necessarily vote, though. It's intended to look at safety and make recommendations. So it's not really a voting.
Right, but if 4 people say we don't need to look into this matter as a safety issue and 3 people say we don't, do you understand what I mean? Mm-hmm. I mean, everybody's not raising their hand and officially voting, but they are. They're either agreeing to move forward with a safety issue to bring to the chief and ultimately the city, or they're not. There has to be a tiebreaker to that decision. Well, said that wrong. You're right, yes. The fire chief is always the tiebreaker for stuff like that anyway, but in the committee,
Yeah. So, yeah, I think we can just propose a definition for that as well in counter. But I just wanted to point that out, that was the only concern, but because there hasn't been a vote in a year on that particular committee. The next one, I believe, was the counter was for overtime pay, hours and overtime. The union had proposed, and sorry, it's not on this particular one, but the union had proposed all employees offered overtime receive an option for overtime or comp time. The city wants to not do that just based on a previous grievance that was filed. In pulling the arbitration ruling, there was never really any clear guidance on that. So we would not like to revisit that issue. And so just to recap, you had an employee who promoted up. He was originally, I think, on shift and he was on days and promoted up and bid on shift. And there was a conflict in how those hours were translated in calculation. So don't want to do that again.
Is there a formula that you use?
So again, so when you're doing, the guys on shift are 40 and the guys on days are 48. So essentially they just adjusted the money. It's based on money value. So the money that he would have had was the same, but
Yes, this is
the hours were converted.
yes,
I don't
I'm
do,
familiar with-
I don't do math.
No. I'm familiar with having to convert the conversion from a 40-hour, staff personnel going back to operations on the 24-hour shift. And there is a formula for that. I don't know which one is used, but, it's something that we've had to explain to, our people that, yes, there's a conversion rate between here and here. And I guess seeing it is shocking to a lot, but it's the way it has to be done.
Well, he didn't like that. So like I said, it was a very expensive arbitration for the city. And we would prefer, so we would not like to give the option for comp time. So
How
that's
long ago did this one happen? Do you know? How long ago did this arbitration happen?
15 or 16. It was a grievance. And it was around the 2015-16. It took a while to arbitrate that one. So we would not like to go back to comp time. The last, and we didn't have a counter on the temporary promotions when the union wanted to strike double upgrades shall not be permitted in operations And they also wanted to take out the mandatory upgrades and no changes after, to the shift after 8 a.m. Most of the deputy chiefs I talked to said that their schedule is completed by 8 a.m. It's not entered into the system, but they are done, and most trucks are in service by that time. I guess that there can be a compromise, but we're just not trying to change when someone goes home sick, not trying to, in the middle of a shift, make major changes to put items out of service.
This was on temporary promotion?
Yes,
article?
sir.
Okay, yeah, just to make sure I'm on the right.
Yeah, I'll pull that up.
Okay.
I think that the concern was at 8 a.m. and there was a comment made that the schedule's not done. Most times the schedule is done, it's not inputted into the system. So I think the concern is not having to make major changes to accommodate seniority upgrades in the middle of the shift where that will require major changes to putting things out of service and shuffling personnel. I think at that point, or at some point, I guess we're open to a discussion on what that time will be, that after that time, it's agreed that the deputy chief shall have discretion to make it whatever changes that are most efficient for operations, whether that's moving one person or not having to put a full unit out of service, whatever's the best decision to make at that time.
So the discussion would be on the 8 a.m. time, right?
Just that time, yes. But I think we definitely want to make sure that mandatory upgrades are in, and that there is a time limit put on when changes to the schedule can be made.
Okay. I noted.
And we didn't have any other counters other than the ones that we discussed in union business.
Okay.
Just to clarify on that one, y'all are saying that you want to leave section 5?
Yes, sir.
Okay.
We wanted, so like I said, in section 1, the union wanted to strike our proposed striking double upgrades. We wanted to leave that language in. And we wanted to leave the language in for section 5, and we were open to discussion on a set time for section 6.
Okay. Noted.
Okay.
And just real quick, can we go back to Article 10? Because I think we're probably close on that one.
Union business,
The department committees.
department committees, okay. Okay, I'm there.
So I think the only thing where we were stuck was on the assistant chief chairing and whether that's a person that votes. Is that? Am I right about that?
And I think there were some additional compensation concerns.
There's also on the second page, G, and then section 3, section 2G, and section 3, A, B, C, and D that I don't think we've come to agreements in those with the drugs, random drug screening, and there's quite a bit in that article that we still probably need to discuss.
Okay.
So we did send over the random drug screen policy. Are we wanting to kind of get into that so we can hear concerns about that prior to lunch?
Okay. The concern is if we're going to implement or talk about implementing a random drug screening process, then it's got to be more encompassing than what's in that policy. I helped put together the random drug screening policy in El Paso, and it's very involved. We looked at national standards, certifications for the lab, process for the true randomness of the list that the human resources managers provided for the people that are going to be randomly tested. So if we're going to delve into that, then it needs to be more encompassing than this policy.
Can we have a copy of a proposed?
I'll let you look at the El Paso language.
So just to be clear, it's not the drug screening, it's the policy itself.
What do you mean?
So it's not that the city's requiring random drug screening, it's just the language of the policy that's a concern.
Well, if the city is looking to implement a random drug screening policy, then it's got to be more encompassing than what you sent me.
Yeah, no, that's what I'm asking. So specific, just to make sure we're clear, it's not the request for random drug screening. It's just the policy regarding the random drug screening. So when we come back, are we discussing the policy regarding random drug testing, or will we be discussing random drug testing in general?
We are well, I guess for clarification's sake, is the city proposing to implement or talk about negotiating a random drug screening program?
Yes.
Okay, then that program's got to be more encompassing than what's in the policy.
So it's not, so the question isn't about
No.
drug screening, it's just about the language.
It's the random drug testing, yes.
But I think Sheree's asking, is the union resisting random drug
course not.
screening, period? Okay, union's good with that. It's
Well,
the implementation of the
Yes,
process.
we would need to, it's a negotiable item, of course. If we're gonna implement or look at implementing a random drug screening program, then it's gotta be all encompassing, not what's in the policy, because the policy is lacking a lot of
Okay.
the mechanics that involve a random drug screening.
So it would be all employees under this agreement shall be subject to random drug screening as adopted and amended by, and then we can just
Appendix,
attach
we can look up
appendix, whatever.
appendix, whatever, and then the policy would be in there, but, you know, the city
Okay.
needs to go out and contract, the contractor that provides the random drug screening, I guess, the lottery, so to speak. And then you've got percentages of how many you're gonna screen
Right.
per year. You know, you've seen those, and I'll send you the El Paso,
Right, that'll be great.
so you could look at it,
Send us that one.
Okay.
but it's more encompassing than that.
Gotcha.
We're gonna delve in those waters, and it's really involved.
Okay.
It's not that hard.
What's that?
It's not that hard.
It was, Kelly, let me tell you.
All right. Anything else before lunch?
Since it's 15 minutes later than it was before, we
know.
can go to lunch.
Trying to,
If y'all are ready.
What time are we back? 1:30?
been ready.
1:30?
1:30?
Was it 1:30?
Sure.
Good, okay.
That'll give us a chance to discuss.
Okay, 1:30 can do lunch and discuss. Thank you.
Ms. Reed, I'm gonna send it to you on my Gmail address. I'm having trouble again with my IFF. And I don't have the time right now to deal with anybody in IT over there. Hold on, let me do this.
Okay, we'll reconvene at 1:38 PM. And we'll start with TA agreements.
So we just have Article 2 as proposed and the changes to the negotiations to commence as discussed. So I didn't have time to add a test sheet, but it just says the union shall provide a formal notice in the form of a certified letter in full compliance of Chapter 174 to the city manager, period. And I think that that's what we agreed to. Go ahead. Yeah, Stephanie will make copies when we get back. And so now, I guess during lunch, we worked on some definitions as well. So we'll present those now. So most of them mirrored what you had agreement. We added bargaining agent and bargaining unit since those were terms that were used in the contract. We also added benefit and budget. Let me correct that one. Business day and calendar days, because those are also defined in the contract. CBA, we reference Chapter 143 and 174, since those are referenced in the contract. Civil service for the same reason. City manager and city. We also added committee chair and included the language that they should not participate in voting to address some of the concerns that were mentioned earlier. We also provided definitions for communications personnel, day personnel, department, employee, execution date, and effective date, since sometimes those are different for the purpose of the contract. We define fire chief and fire department, fire suppression, and then some of the other fair labor standards, some things that have come up in the past. I think our grievance language is similar to what you propose. Labor agreement, management rights, which will eliminate the changes for the new, potentially the changes that we were proposing, hopefully to eliminate that. Overtime pay, parties, probationary firefighter, shift. Union business, we basically just, instead of just doing internal, we just define union business and pull that language from the contract and that original provision, so we could, I guess, eliminate some of the other, or talk about some of those other changes. And then work cycle, mostly just for calculation of overtime and some other financial stuff. So we can scroll back up to the top and I guess go through them with the ones that are standing out as giving the most pause.
You wouldn't happen to have a printed copy of that, would you?
I don't, but I can get you one. Just give me 1 second. I'm gonna email it to her so she can print it and bring it down. Just give me 1 second. Okay, so it'll be down, I guess, like shortly. Are we okay to, I guess, to discuss while we wait on that? Shouldn't take long. No, I guess I already went through them. I guess I wanted to know if there was any that like gave great pause when I was scrolling through them.
Yeah, well, we're gonna need to discuss all those, but I saw something that said Local 571.
That might have just been a typo. I'm sorry.
Right there, labor agreement.
Oh, sorry. I'll change it. It was our, I guess, like hope to kind of get, have a discussion over. So if we did need to caucus, we would know kind of what we were all. So I don't know if y'all want a moment to talk amongst yourselves about it, or if we can just kind of all talk openly about it.
You have any questions on it right now?
I don't have any questions for it right now, but with there being so many definitions up there, we do want some time to comb through those so that we could be more thorough in our decisions.
Yeah, I'm gonna have, no, have somebody bringing down the,
So, once we get all the copies, if you want to caucus now, we can, or either we can keep going.
Yeah,
You do
we
it
have- yeah,
later.
let's keep going,
Okay,
and, we'll identify other things if we need to talk about in the caucus,
Okay.
instead of breaking get some momentum going.
we'll probably need do you want to wait till we get the copies to start looking at the other articles? 'Cause we're gonna be referring back to the definitions.
yeah, let's just,
We'll wait on the copies.
Okay. We'll take a short break.
A long break.
Do you want to take up one short topic while we're waiting on that? I'll call it short. It might not be short to you, but rather than waste time, if we can just take up something on the assistant chiefs.
Yeah, okay, so so we're all kind of on the same page, I think our hope for today was to have the proposed definitions and then go back to management rights, union business, seniority, promotions, demotions and transfers, maintenance of standards, hours and overtime, and temporary promotions, because I think some of the definitions will inform those articles. But one that isn't waiting on a definition is I think Article 7. So if we want to look at that while we're waiting to get the definitions. And I think where we left it was the proposal by the city is to have the contract read 2 assistant chiefs will be appointed by the fire chief. The union didn't agree, and that's kind of where we're at. So I think that's one we can just have some more dialogue on. That doesn't require a definition unless y'all see it different.
True, and I believe we have a counter on that.
A counter okay.
Yeah, I mean,
So what's the counter?
If it's a major change, then I think we need to project it on the screen. If it's just like some minor wording, I'm trying to find it. What page is it in the contract?
working document, page 9.
Page 9. Then I passed it a long time ago.
I'm showing it on page 5.
Okay, let me. Thanks. Yeah, I appreciate it.
This is
What article is it?
Article 7.
Article 7. Thanks. All right, thanks.
I've got it here, yeah. Yeah.
Here's the language as is. Are we in section 3 with changes?
I think so.
Okay.
So section 3, well, you don't have the counter up, but.
Oh, the counter's on the thumb drive, I guess. Is that?
Yeah, I mean, you don't have to put it up, I just,
I can get it, hold on.
The suspense is killing me. Are y'all proposing 4 assistant chiefs or, yeah?
5.
So just the seniority promotions one.
Yes.
All right. So the original language of section 3, we just left the same, with there being additional parameters below in A and B for any additional assistant chief. So A, we propose setting a trigger number of 300 to add a second assistant chief. That number comes from 143. That's the trigger number for a second assistant chief as far as 143 is concerned. So it just seemed like a good number, to pick there. Again, that's considering we grow the department, then we need a second assistant chief. I mean, I don't want to beat a dead horse. I think we had that conversation already. And then B, that additional assistant chief position would be tested instead of appointed. Yeah. And then C, I think we talked about it before, but C is just unnecessary language. He falls under the contract and always has.
So the city would
just
be
one-
getting, yeah, go
Just
ahead.
1 second. As it relates to C, that has not always been understood, which is why we had to add your assistant chief to the wage table. So I disagree with that. I think that there has been a confusion about that in the past, and to eliminate future confusion, I think it's important that that language be added.
So he's always been a bargaining unit member.
He has, but
We've
he's-
always recognized him as a bargaining unit member. The city might not have, but we always did.
I don't know, because there was a lot of argument to not add him to the wage table from your side of the table.
It
So
wasn't an argument, it was discussion. And we just asked questions.
tense. Pretty tense. If that was your contention, then I don't think it would have been a discussion, which is why I think it's important that that needs to be in there. As it relates to your contention on A, that's already a right that's guaranteed by the city, so I don't think that that needs to be in the contract. Once it's 143 already allows for that. So there's no
no.
point in contracting for that if we're just going to follow the statute.
We have,
And then as it relates to the assistant chief being tested, the current position isn't tested, so that's a reduction in management rights.
so we
Kelly,
have.
did you have something else on that?
We have 174, so it's not automatically afforded at 300. It's negotiated. It's the only way you get another assistant chief.
That's under 174?
Correct.
what-
We have collective bargaining, so the only way that you get the second assistant chief is if we negotiate it. It's not automatic.
I think the city automatically, under 143.014, if they've got between 300 and 600, they have the right to an appointed second assistant chief. So the city's not going to bargain against itself and make it more restrictive than what it's already allowed to have by law.
Okay.
Yeah, this is already contemplated under 143, that the city has actually not just the right under A, but the right to appoint and not have it as a tested position. So the city will not agree to that. And I think we had said, when this came up the first time, this was, there's obviously flexibility, and part of the negotiation is going back and forth, but the second assistant chief is one that the city feels pretty strongly about.
Well, that's the only reason that we're talking about it right now. If
Well, but
you're
you're
flexible,
talking,
then be flexible. If you're not, then just say you're not going to accept anything else other than what you proposed. What's the point in talking about it if you only want what you asked for?
well, that's what we're here
See
to
what I
be able
mean?
to do. But yeah,
Well, that's what we're offering is a middle ground. So
But this is not a middle ground. This is a step back from what the city already has
it's not a step back because you get another assistant chief that you didn't have before.
at 300 personnel, which the city gets anyway at 300. And they don't have, and it's not a tested position, it's an appointment.
So the purpose of that is to show a commitment to growing the department. If you don't like the number 300, then pick a different number.
Hold on just a second though, before you do that. 'Cause I want to
I'm happy to
back
pick a
and
number.
reference
I like it, though.
143.014, where it says that that this subsection does not apply to a municipality that has adopted the Fire and Police Employee Relations Act unless the municipality specifically adopts the appointment procedure prescribed by this section through the collective bargaining process. Yeah. In other words, since we do have collective bargaining, which is what the Fire and Police Employees Relation Act is, since we do have that, that this is a topic that needs to be negotiated. It's not something that's automatically triggered when we get to 300 personnel.
Question. Why do we want the testing provision when we don't test now?
Well, you don't test now because 143 gives you one position to appoint. If you're asking for additional positions, then we are asking that those be tested for.
Okay, that's my question. It's like, okay, we don't test now, but you want us to test.
Any additional positions? Yes, sir.
So
That's our
one
request.
position would be tested and the other position would be appointed. So when that original position is vacated, it wouldn't require a test?
It could if you agree to it, but we're not looking.
But we're just talking about purely the language that's being proposed and what the intent behind it is. Right now, you have one position that's appointed and you have one position that's tested. So when that one position that was appointed is vacated, that position will remain an appointed position.
Well, isn't your intention by adding the second assistant chief to take the current assistant chief and make him an administrative chief and then to have an operations section chief?
That's not the question that I'm asking.
Is that the purpose of the additional
I think that'd
language?
be up to the chief, but my question was, when that position is vacated, the one that's appointed, would that now be a tested position or would that remain appointed?
So the answer to my question matters in what you're asking.
You can't ask a question with a question. It's whether or not the intent is to make both positions tested or to leave one tested and one appointed.
Okay, then make both of them tested.
So first of all, I'm not entirely sure I agree with the way you're reading 143 and the limitations. It says the municipality can adopt the procedures for additional appointments. So frankly, I've never had anybody push back on the second assistant chief, and I'm not sure I'm reading it the same way as you, which is that it's not automatic once they hit 300.
I think it's important to note that we're not necessarily pushing back on the position, but it does say that the municipality specifically adopted through the collective bargaining process.
Right, I can read that, but if the municipality has the right to adopt it, that suggests that there's some unilateral discretion on the part of the municipality.
Yeah, I don't see it the way that you do. It still says through the collective bargaining process, which takes away the unilateral decision.
Well, but it says that the municipality may adopt it that way, so. Either way, I think that again, the city is committed to having the two assistant chief positions. Having it tested really, it doesn't accomplish the goal, which is having the additional person who is selected by the chief, that the chief has some discretion over in helping run the department.
Isn't your goal to have another assistant chief to help manage the department? So what does it matter if the chief appoints the person that he wants to do it, or whether you test everybody's ability to be able to do it?
Because you're reducing his rights underneath the contract. If you want to go by past practice.
It was a tested
and say-
position before. It only became an appointed position in 2010.
There's been several things in the contract that were a way before, and then it changed.
Right.
Then you argue maintenance and standards. You can't have it both ways. The maintenance and standards now, for the last 14 years, is that it's been appointed. And so if we want to start doing that.
Maintenance and standards is in between agreements. We're trying to settle an agreement in here.
There's been multiple conversations about, if we do that, that'll change. And there's some things, if you change that, it'll affect maintenance and standards. So you can't have it both ways. You can't say, this is one way when it benefits you, but then not when it's a detriment to the city. The other question that I have is that you said when the manpower of the department reaches 300 personnel, are we talking about the department as a whole, or are you talking about as it relates to firefighters?
It says civil service manpower.
So again, we're talking specifically about firefighters.
That's who works for the fire department. Yes, we're not talking about secretaries. And maintenance of standards is an article that covers benefits
Then I
in
would argue,
between.
I would argue that your additional language for civil service manpower connects very closely to ongoing litigation. And we unless you want to reword that, we can't accept that language.
I disagree with that statement that it has anything to do with any ongoing litigation. It has to do with a proposal that you guys made to us, and we've countered it
So
in
again,
accordance to.
the language of civil service manpower is the direct issue in an ongoing litigation. What's considered a civil servant, what's considered a firefighter, who's entitled to those benefits is a direct issue in an ongoing litigation. And so again, unless there's some rewording to that particular provision, then I don't think that it's appropriate to discuss it without your attorney present.
Can we move on
You
to
can
the
leave
next?
it as an unresolved issue and move on.
Yes.
Thank you.
Want to go back to management rights? So I think the hangup here before had been on the word full,
Yes.
right? So we've defined management rights in the definitions page that y'all got. And I think with that, we are willing to agree to remove full and leave it the way it had been previously.
Okay, with the correction on the workforce, one word, we're gonna make
Right,
that.
I'm just talking about the substantive provisions.
Yeah, the word full, we got stuck on last time.
Right. Do we need to talk about that more with the management rights definition?
No, not at this time. I mean, we recognize that the city has management rights.
Is that when we can get ready to TA?
Yeah, if you're gonna remove full, I mean, that,
But that comes with the adoption of the
Right.
the definition, so.
we can make an asterisk depending on the adoption of the definitions.
Well, can we look at the definitions now?
All of them?
No,
That one.
just look at management rights.
We're not prepared to look at that right now.
Okay. What about the next one? Union business was one that we had left with needing to come back on a definition. So we've got a proposal for union business.
This is the wrong working
With that definition, does that do away with the wording that you had added to the, I don't remember which section it was, but
Yeah, it was in,
section 5? So it just leaves the existing language if this definition is agreed on. Is that right?
hang on, let me get there.
Okay. Yes, sir.
Referring to Article 6.
No,
Yeah.
Article
so
6, section 6.
Right, so we would get rid of what had been added in there before, and it would be on section 5, except as otherwise provided herein, union business shall be conducted during the non-duty hours of the members.
Never mind.
Period, and the rest will be stricken.
Right.
Okay.
And then section 6, we had talked about I think the proposal before lunch was to have 3. Officers or delegates granted time off for the conferences, seminars, job-related conferences and seminars. Yeah, so we're on Article 6, union business, and we've made a proposal in the definitions on what union business is. We're agreeing if that language is adopted, then we would remove go back, Sherry,
Right here?
up a little bit more to the next page.
What section are we in?
Right there, section 5. So that would come out if the language in the definitions is approved. And before lunch, we had talked about our proposal on section 6 was for 3, no more than 3 officers or delegates.
Also, Kelly, in section 5, internal and regular business would just be changed to union business, because that's how we defined it in the contract, in the definition section. So here, we just say union.
I had a couple of questions. So representing the members of the bargaining unit and disciplinary actions, I just want to make sure that we're clear on this. That does happen on duty. So if a union steward is on duty and somebody gets called for a disciplinary meeting, typically the steward goes to wherever that location is and represents the member, whether they're on duty or off duty.
So that was already
Yeah.
that was already existing language. I just cleaned it up. So we didn't change that language in section 2. That was already existing. It just said unit employee, and we just changed it to a member of the bargaining unit. But that was already provided, and it already says that he's granted reasonable time off. So when we define union business, we just use what was already existing
Well,
in the contract.
right, but I guess my point is, the purpose of this definition is to cover section 5. Section 5 is about what we're allowed to do on duty while we're actually working. And what I'm saying is you included representing the members of the bargaining unit. Yeah, we can be released from duty for that, but we typically don't go through the hassle of releasing people from duty. They just, if there's a disciplinary meeting in the chief's office, then the B shift steward gets on his engine, goes down to headquarters, they have their meeting, and they go back in service whenever it's done. So I just want to make sure that I understand the intent behind the addition of that as it pertains to section 5. I know that it's not changing anything in section 2. Do you see what I mean?
I take one of the concerns that we would have with that is that if those members are not allowed to just take an engine and go down and represent that member at that time, it could delay that process because they would need to schedule someone who was off duty or release someone from duty. Past practice, maintenance of standards, as you said before, we've always been allowed to, if someone's called down the last minute for a supervisory inquiry, if they're called down for disciplinary, we've just, as Cody said, been able to go. If we're unable to do that, then there could be scheduling issues that would just delay the process. We don't see why we would want to delay the process in any way.
Aren't y'all given notice of those things prior before they occur?
In best case scenario, yes. In a perfect world, yes. A lot of times right now, no. We've had many members who have been called into the office before, putting themselves in a situation where they could be disciplined, where they're entitled to union representation. And sometimes that happens without notice. Of course, whenever you're going through a formal disciplinary process, when there's a hearing, members get notice. But whenever it becomes a supervisory inquiry, something that's, I don't want to use the word less important, but a smaller infraction, they sometimes get called down to the office and they would like to have a union representative with them during those interviews.
So, Cody, you think this clause might interfere with the requirement that the union business not be done on city time, or what?
No, sir, I'm specifically talking about the representation of our members.
Yeah, that's when I say that clause, just that section of the definition.
Right,
representative
investigating and
bargaining unit
processing
and disciplinary
grievances,
actions.
that's typically done by us, and we're either released from duty to do it, or we're able to do it while we're off duty. The civil service meetings, the officers that would be released for that, are typically the only ones that need to be off work or go to that anyway. Arbitration, same thing, unless they're subpoenaed, and I think you mentioned that earlier. If somebody's subpoenaed, they have to go. If the department doesn't want them to go on duty, then it just they just have to backfill that spot, I guess. To allow them to go off duty because they're required to be there. And court hearings, the same thing. So, the representation of the members is really kind of at least for me, that's what catches my eye.
Right. So even with notice to a hearing, if you have a B shifter that's being disciplined and his B shift steward is to go to that hearing with him and represent him, that B shift steward would need to be released from duty to be able to do that, which could cause scheduling problems.
Okay, so hearing makes me think it's more formal. Are we just talking about the meeting in the chief's office, or are we talking about like the actual hearing? Because I think a hearing, you would have notice.
In this example, even with notice, and I'm talking about even a formal hearing, your B shift steward represents your B shift member, and requiring that B shift steward to be off duty to go down to represent his member who is on duty seems counterproductive. if you and I are on the B shift together and you're my shift steward and I'm in trouble, I get called down to the chief's office, but for you to come in and represent me, you have to request off from the fire chief, and they have to fill your position while you're off representing me, by the way that's written.
I don't think anybody has any issue with members being represented fairly. I mean, even the fire chief has been pretty good about making sure that members have representation if it's necessary. So, I mean, we could just strike that particular one off of there, and I think we'd probably be okay to move on.
So in section 5, if we just added that this wouldn't apply to members being represented by their stewards at hearings, would that adjust that?
You could just strike that part off of the definition, and that would do the same thing, right?
Let me pull up the definition so we can all look at the same thing.
So if you strike it, it wouldn't be a part of union business, or what?
It just
Because it is a part of what you do, right?
No, it's definitely still union business. It's just I think this definition is specifically for Section 5, right? Does it have implications in other parts of the article?
So we took it off, and again, wasn't thinking about the union steward position, but we took it off as it relates to, in arbitrations, there typically, it's the grievant and then a member of the union present as well, or several members of the union present for that purpose. So again, that wouldn't apply here. We just took the definition specifically from that first line where it says shall be granted reasonable time off, because we considered that to be the union business that was previously defined in the contract under Section 2. We thought that it would alleviate the additional extra language in Section 5, but hearing your concerns, it sounds like it now raises an additional issue of representation by the stewards.
I guess that was my first comment. I would ask, was the problem you felt like it conflicted with the Section 5? That was my first conflict.
Well,
You're saying that's not what you're concerned about, it conflicting with this Section 5 on the union business?
No, I don't think that they conflict, because Section 2 is,
I mean, not Section 5, Article 6, I'm sorry, Article 6, union business. Do you think that clause or section or after the end conflicts with union business, maybe how we were talking about it earlier today?
I'm sorry, Mr. Williams, I don't think I understand what you're asking me.
That's okay.
you want me to translate?
Yeah,
Okay, I think what he's asking is, did the definition that was proposed, are you concerned that it's reducing some of the rights that we talked about this morning as it relates to Section 2 and the things that we discussed as it relates to Section 5? The definition portion.
No, I don't think so. It's just
Okay.
that one section is for the purpose of granting time off, and the other section, which is 5, is about what we're allowed to do on duty.
Okay.
And that union representation, the disciplinary representation is specifically something that has always been done on or off duty, depending on when the situation happens.
So if we amended or added language to Section 5 that said that union stewards were allowed to represent in their capacity while on duty, would that alleviate some of that concern?
When I gave the example earlier of a union steward, it's not necessarily always a union steward. It could be myself, it could be Cody, it could be any of our other principal officers that may go in and actually represent someone. So, I mean, if we left it as a union officer, that may be better than a union steward. But yeah.
What his point earlier about the stewards was just that typically we try to have B shift steward help B shifters, A shifters, and so on. There are situations where somebody gets called to the deputy chief's office or to the fire chief's office. It's something more minor than normal that didn't necessarily register for a full disciplinary investigation. And the B shift steward isn't on duty that day. So there's other board members that are on duty. I've gone and done that in the place of several of the stewards in the past because they're not available, they're not on duty, they're working a second job or whatever. They're just, I guess ultimately, what we're coming around to is we just want to keep the flexibility to be able to represent our members when a situation arises. And if we put this in here, it's going to diminish that a lot. Like,
So
You want to be on duty when you want to be able to be on duty when you do that.
we don't have to be. I've represented people on duty. I've represented people off duty. The flexibility there is the key. So if there's somebody that's available off duty, great. If their steward is on duty and they get called down to the office unannounced, great. I don't think that there's never been any issue with that I'm aware of.
So again, the I guess the thing that would be the compromise is to add language that not steward, but union officer or a union representative. Like how do you?
Union representative, I think, would probably be fine.
So union representatives would be allowed to participate in inquiries while on duty.
Disciplinary actions.
They get it right.
Yes.
Doesn't have to be.
Yeah. Yes, I think so. Yeah. If
Representative is.
looking at it on there would be helpful, but just listening to you, it sounds like that would probably make it work.
So this would be union representation during disciplinary actions. Is that broad enough?
Any meeting that has the potential for disciplinary action.
Explain to me what that means.
Well, if we start getting too specific,
No. I'm just trying to because if you say any meeting, because, that could be,
That may result in disciplinary action.
well, that's the thing,
Qualify the meeting.
I don't know, because you come in a meeting and it was just to ask a question, but you go in the meeting and you lie, then that meeting could result in disciplinary action because you weren't truthful. It creates a whole nother issue.
Good.
But that wasn't the intent of the meeting. So it could become a situation where there was no necessity for representation, but then it became a necessity for representation because the individual either was not truthful or made other admonishments. So my conversation to you is that we started the conversation by saying if he was being called down for an employee inquiry, I don't know the specific terms, that obviously has the air of some type of disciplinary stuff, but any meeting that could result is very generic.
In the firefighter world, if you're called to the chief's office,
It's bad.
it would probably result in discipline.
Oh, okay.
It has been my experience. I don't know if the chief could speak to that. No?
He has challenge coins in his office. It's a fun place.
He's calling me down to give me a challenge coin.
Who knows? It's a fun place.
Could you just put union representation will be permitted on duty, period? Wouldn't that
On duty.
make it work?
Shall be permitted.
I think you need to qualify if it's going to, for what purpose. Because if, again, I don't know.
Don't do
I
that.
don't know
We
that.
don't have that in there now. And
No, it's a situation where it just says that except for the things that are in section 2, that you can't do anything or specifically not supposed to do anything on those things. But that's even delineated just to the union president or his designee. I don't think it's intended to reduce the rights of the union steward. If you're saying that that's a practice that y'all have, that the union steward is allowed to represent on duty
well,
in involuntary things, and I think we need to clarify that so that there's not a confusion moving forward.
what I'm saying is we don't have a problem with that. The only reason we're even having this conversation is because you wanted to add language to the internal union business section. There's never been an issue that has anything to do with representation of our members. Is there? you keep making these faces when we talk about things. If you know something, then say it. I mean,
My face is my face, and if it offends you, I'm not
it
going to
doesn't offend
apologize
me. I
for
didn't
it.
say it offended me.
but-
I just,
It's not. It's just my face. I can't
if
help
there's
it.
I know, but if there's an issue with our members being represented while they're on duty, then let's talk about it.
I don't think that
Again,
there's an issue of your members in representation. I think, again, it's, unions have the ability to represent their members. I think we're just trying to clarify it so that it doesn't become an issue. You keep saying that it's never been an issue. Of course, it's never been an issue for the union, but it may have been an issue for the employer. There's also a situation where we need to clarify things so that it doesn't become something that's debatable in the future. Hence the definition for what is union business. If you're telling me that your concern is making sure that your union stewards or union members in general can provide representation on duty, then I'm asking if we propose language to that, would that be acceptable?
Depending on how it's worded, I guess.
Well,
Yes.
obviously, I'm just saying with that, the language is what's being
She
discussed.
said
I'm saying-
proposed
Yes, if
language.
you propose it, we'll look at it,
I'm
yes.
saying, would that address, is that the only concern you have, is that union?
Just the represent, yeah, I get what you're saying. Yes, I don't, do y'all see something else in there in the
No,
definition?
I think since, I guess we're whittling down union business, not on duty, then we opened up another can, I guess, of when that occurs or doesn't occur. Is coming down to the chief's office, and if he tells me he's giving me a challenge coin, then I don't need to call a steward.
Right,
Unless he changes his mind while I'm on the way down there.
right, unless you show up drunk.
Then I wouldn't be at work, believe me. I'd be somewhere else. But anyway, it's just the disciplinary aspect and the representation aspect. It's convenient, like Cody mentioned the examples. You bring somebody in on B shift, there's somebody available on duty to take care of it. You bring somebody in on C shift, there's nobody available, then it encumbers the process because you got to find somebody. So we're just trying to make it, I guess, to where we don't lose the ability to represent our members if there's somebody available on duty for a disciplinary meeting.
Gotcha. And that helps. Like, we were just trying to, my questions weren't intended to be attacked. It's just to try to
I got to
narrow down.
translate.
Yeah, narrow down what exactly the concern is so we can bring back language that may resolve the issue.
And that's a concern, right? Representing our guys while if someone was on duty and make it, I guess, not to make it cumbersome.
Got it.
Yeah,
And we'll come back with some more language.
thank you.
On section 6, though, I think that there was a conversation about 3 versus per shift and not per shift. Can we, I guess, because I guess the concern was if you did 3 per shift, then we're talking about a total of 9 personnel over a course of a week, as opposed to just 3. So that's why I asked on average how many people attend, and we came up with, on average, 6 people attend. But it could be, it could be more.
Right, well, the people who are off duty, who are not having to request to be off duty to attend those, don't need to request to be off duty. So we're only looking at the people who are per shift. Right now, we allow 2 per shift. We were suggesting to go to 3 per shift. If I'm not scheduled to be on duty and I'm one of the 9, then I don't need to request to be off duty. The chief doesn't have to give me approval to attend a conference if I'm not on duty.
But wouldn't you be on duty sometime within those 7 days?
Maybe not.
If you weren't on vacation?
Or Kelly Day. No, maybe not. So that number 2, like I said, right now, currently, the way that the practice has been is that it's been 2 per shift.
But outside of being on vacation, what's another scenario where you would not work during a 7-day, or you would not be scheduled to work during a 7-day conference?
Kelly Day.
But you get a Kelly Day, like so if the conference is Monday through Friday and you left on a Sunday, your Kelly Day's on Monday, you would still technically be scheduled to work on Wednesday.
I think we're really getting in the weeds on it.
I don't think we are, because we're talking about how much money that would cost the city potentially.
sorry.
Your schedule, you wouldn't be working Sunday and then Monday, Kelly Day. Sure, on overtime.
I'm just saying, like, even with the Kelly Day, like, at some point, you're going to work within that 7 days.
So right now, we're allowed to do 2 per shift. That has nothing to do with the people who are not on shift right now, right? So there's 2 people that are on shift today that got to be released.
That's for negotiation.
Tomorrow's another shift. 2 people could be released to go tomorrow. That's not the same as the other people who were released the day before.
Okay. I understand that concept, but I also think that there's just a part that I'm missing. The part that I'm missing is that during the process of that conference, at some point, people are going to be able to work, be scheduled to work. So if you limit it to 3, then whether it's across 1 per shift or across just impacting 1 shift, you limit versus for a full week, there's multiple shifts that are impacted. I guess what you're saying now is that the current practice is 2 per shift. And there's a request to kind of limit that to just 3.
Has 2 per shift been a problem?
And we've never, I guess, as it relates to them going to conferences, I think in some situations, not necessarily for a large-scale problem, but there was an issue where there was a seminar hosted and several members wanted to be off. And that created a problem. And since there was no contractual language for that, so I think, like, again, we discussed, like, if we're saying 6 total, and that's, whether that's 6 from 1 shift or 6, from different charges, we talked about that because that was the maximum number of people that could be off. Or if you're saying that, it needs to be, per shift, and you're increasing that 3 per shift, we're talking about a total of 9 people.
Yeah, theoretically, but I mean, the people that wanted to go that you mentioned were not allowed to go? The chief did not approve that leave, or what happened in that scenario?
I don't know what the full scenario was. I know it was quite a bit of individuals were left out. I think that some of the officers were allowed to go, but the individual members, because there was more discretion in that one, the chief does have the ability to kind of deny that. I don't think that was a problem, but the way the word is worded in section 6, it says shall be. So there's not a lot of discretion for that. So it says union officers and elected delegates shall be granted time off. And so if we're talking about adding that, then again, we're not trying to reduce the rights that they have, but if you want to take out the word shall and give the chief discretion to approve or deny a certain amount, I'm not trying to tell you how to do it, but I think the better option would be to leave the shall in there because it does allow protection to union and the members to be allowed to do that, and then just agree on a solid bare number because the language is shall.
I really think I'm starting to understand what you're talking about, but we'll just talk about it in a caucus because I don't think we're saying too much of a different thing.
Right.
So the more I look at this, the more I listen to you, I think that
I think we're
pretty
close.
close.
Yeah.
Yeah.
Okay.
We'll talk about it and we'll let you know.
So I'll just, as Mr. Tez says, put a star by that one.
Yes, put a star by that one.
Okay, the next one's the maintenance of standards.
Which one is that, Kelly?
It's Article 9, Maintenance of Standards. So I think the last discussion was about the addition of A, defining benefit. As it was here, we moved benefit into the definitions. And I don't recall if we ever got a counter to the additional language in A and B under section 2. But what I think where we're at is we can take A out under section 1 and just rely on the definition section, or the what's in the definitions. And then if y'all have something to discuss on section 2 for A and B, we can talk about those and see if we can get closer.
And so I will add that the A and B came as we proposed the creation of a operational guidelines committee. And the idea is that the union members or board would be in that committee to discuss policies and discuss those things. And we want that to be clear, that any proposal or recommendation coming out from that committee and being presented would not be a problem.
So B refers to the Operational Guidelines Committee. You speak up?
So A and B, because a new policy could definitely come, or a recommendation of policies will be coming from that particular committee.
And there's currently a policy committee?
So we don't have a policy committee. So the idea was to create the operational guidelines committee, which would essentially be workshopping and drafting implementation of new department policies. So that would essentially be the committee. It doesn't exist currently. I think in the past, there have been ad hoc committees that were open and then closed or just didn't do it. But the idea is that that would be a standing contractual committee for that purpose.
I think that defining benefit, the way that you guys defined it, destroys the entire validity of this whole article. So the intent of the article is to keep benefits that aren't specifically outlined in the contract in place in between agreements. So if you put that in there, you may as well do away with the entire article, because that's what that's doing. If it's not in the contract, then it's not a benefit by the way that that's defined. So that's why we struck through it before in our counter. Because it just changes, it removes all the intent of the entire maintenance of standards concept.
Well, I think maintenance of standards is the concept of some benefit that flows from this agreement. And outside of that, it falls into management rights, which the chief has the right to control. And I think there's been some disagreements over what actually is a management right versus what is falls under the maintenance of standards.
I think that the word benefit is a key word that has to do with that. You know, we could put together and establish a policy committee, but that policy committee should not have any authority to change anything in that committee that affects the benefits of our members.
Well, right, but and that's the
So,
problem.
and
let's
that,
put
and
it
that's what
members.
that's what we're saying with your definition of benefit in here, that it takes all that away. I'm in agreement with Cody, practically read my mind, that this entire article is in here to protect the policies that we have in place that are of benefit to our members. We have several policies in the department that have been in place for a long time that are of benefit to our members. We've had recent arbitration rulings that specified that, and that changes in those policies would be required to be handled in a negotiation setting. So that's why we have issue with that.
And then, so, and my comment to that is that I think your definition then really obliterates any protection for management rights, because management can't change anything because you consider everything to be a benefit. So
That's not true. That's not true. Things that affect our pay and our working conditions are considered benefits of our employment. Like I said, if the city wants to change the color of the fire trucks and they want to change policies on that, they can change policies on that. If they want to change what time we wash the fire trucks in the evening or what have you, they can change that. They can change policies that don't have to do with our benefits. But when it comes to other things and such that are being brought up in here, temporary promotions or how temporary promotions occur, that's a policy in our department that's been in place. That affects the pay and the benefits of our members. Those are the types of policies that we don't believe should be able to be changed unilaterally by the department.
and again, I think that falls into management rights, and so it's not just the color of the fire trucks. I mean, obviously any policy can, I think, be twisted to suggest it affects a pay or some other compensation indirectly.
Well, we have an arbitrator that just ruled recently on an overtime policy, and they ruled just that overtime is considered to be a benefit to our members, obviously. But the department tried to change that policy that had been in place for a really long time. The arbitrator came back and ruled that that is a benefit to our members and that cannot be changed unilaterally by the department. So.
And I think the city's position is some of those things should be subject to the chief's discretion to manage the department, which falls into management rights.
Right. We can agree to disagree, but I believe that anything that has to do with the pay, benefits, and working conditions of our members is exactly what we're here for. And exactly what this article is intended to be for is the maintenance of standards to uphold those benefits that are in place.
Okay, we agree to disagree, but I'm gonna take executive privilege and take a 10-minute break. I need to. Okay. We'll return at 2:56. Are we ready for attention? Okay, thanks for the patience there, for sure. We're gonna resume, we'll continue talking about definitions, see if we can work through those today for the first round, and whatever we don't resolve, we can bring it back and talk about it.
All right, Kelly. What's the next section?
Next one is hours and overtime.
What section is that? Or article, I guess.
That's 23.
Okay. Thank you.
So I think, and you'll see there were some definitions for some of the staff that are identified here in what we proposed. And then where we left the substantive discussions, I think, was the city is willing to agree to leave the schedule as it currently reads. Yeah, there we go, under A. But wanted to add that the chief has the final authority over the assignment schedule, and that's to ensure there's no issues with overtime in the communications.
So, sorry, it was in section B, to not augment the language in section B, but to leave the fire chief shall have the final authority.
You're saying strike everything other than the fire chief shall have final authority over the assignment schedule.
So in section B, in section 1B, the changes, there were just no requests for increases, and the city isn't imposing a request for increase. So the 250 is just the current contract rate. So we just took out the other increased languages. So that's not a really substantive change there. In section 2B, we're proposing to leave the schedule as is. And so all of that additional language will come out, and the only remaining language would be this right here.
And there was no changes to it, correct?
No, so no additional changes. So the only other thing I would say is that it would be the fire chief or his designee.
Okay,
And so there will be no additional changes to B.
okay. Just the fire chief or his designee shall have final authority over the assignment schedule.
Yes.
Okay. Then on section 1, go ahead. Go ahead.
Section 1B, it was just we just removed the contractual increases from the old contract language. Yes, sir. So the current rate is 250, and that's what's reflected.
Forgive me. I think we talked about this a little bit before. The assignment schedule, what specifically is that referring to? Not the work schedule, but like what are we saying he has final authority over that he doesn't have authority over now?
It may be the change of art, but the chief would be essentially approving overtime. The submission of overtime is my understanding that this is the only chief that has the ability to put in his own overtime. So this is the fire chief or his designee will have the ability to see when that individual was scheduling themselves for overtime or putting in overtime for themselves.
Is that policy driven?
There's currently, I guess, there's a policy, I guess, in that department for it, but this would be the right underneath the contract for the chief to do that. So I don't understand what you mean by policy driven.
I mean, is there a policy over the overtime in that division?
I believe that they have a policy. I'm not sure.
It's just, I guess, no positions, typically nobody can approve their own overtime. if, you know, you just have to get approval from someone, I'm sure y'all do, before you go and prove yourself to work overtime.
I guess, so there's a district chief that's over that office, and he has a deputy chief. I'm just trying to make sense of the fire chief wanting to be involved with overtime assignments.
Which is why we said are his designee. So he can designate that to the deputy, I believe is the one that's over the logistics department. Division.
The idea is just for somebody to not be scheduling and allowing themselves to work overtime without some layer of oversight, which is consistent with how the rest of the department, as I understand it, is handled. Anything else on that, or any feedback, discussion?
Okay, let's move on.
Temporary promotions is the last one I had.
What article is that?
That's 26. And we had touched on this before we broke for lunch. I think the issue here was on the double upgrades and the upgrades being mandatory. And we were waiting to see if there was a counter or feedback.
No, so we discussed this. Go ahead, Cody.
So we stand pretty firm on what we talked about before on the upgrades being mandatory. I think we're willing to be flexible there. I think that the issue is whether or not people want the upgrade or not, and it causing some sort of an issue for the deputy chiefs, which is probably how it ended up here. So if that's the issue, then I think that we would be okay with if a member doesn't, I don't have it written down. I can if you want, but if a member doesn't want the upgrade for the shift, then they should communicate that to their deputy chief prior to reporting to work. That takes away the issue of the deputy chief not knowing that somebody doesn't want the upgrade. It also takes away the issue of forcing somebody to do a job that they
Are not comfortable with.
yeah.
I don't think we want to put that in the record,
No.
considering part of your job
Comment.
description is to do the job above you. What if we put in, because I think previously there was a proposal that employees had to put in writing that they did not want a temporary upgrade, and that writing would stand until the next shift when they revoked it in writing. So that would eliminate, I told them I didn't want it, and there not being a record of that. I think having a written record it's what's been the bigger issue.
You're saying what I said basically, except through email? Is that what you're saying?
Just in writing, so that it would basically, if an individual said, they know, like, I'm never going to want to feel comfortable in that position. I'm comfortable where I am. I don't want to do the district chief job, the deputy chief job. They would, in writing, say, I am requesting not to be considered for upgrade in writing, and that would be and remain in effect until they send an email that says, I would not now like to be considered for upgrades.
It can be.
Yeah, that
Again, the
was,
way you just said it is correct. It's a comfort level thing. It's a decision that's made by the member, and it always has been. It's not that we have people that are incapable of doing the next classification above them. That is a part of their job. That's not what we're saying at all. I gave quite a few examples when we talked about this before of reasons of why someone would not want to upgrade. And they're valid reasons. So, yes, if somebody never wants it, then send that email. If somebody doesn't want it tomorrow, then just make sure that that's documented before the start of the shift is what we're saying.
And I would clarify, excuse me, I clarify my comment. If you're an older firefighter or driver, whatever, you say, no, give it to the young guy. Or, I'm comfortable at my station, I don't want to move, across town or wherever. That's what I meant by comfort.
So I think that's what we're trying to eliminate, that like, because sometimes there have to be, like right now, there are changes that are made in the middle of the shift. Well, if the person who's supposed to take the upgrades is known, we have to go to the seniority list to figure out who's next in line for it. That requires some people to be moved around. What we're trying to do is streamline the process to reduce the amount of grievances that are had, because a deputy chief was trying to rush in and miss that somebody was promoted 1 minute earlier or one day before somebody else on the list, and somebody else got the upgrade over them. We want to eliminate that because somebody else turned it down, right? So what we're trying to do is streamline the process so that if there's a necessity to make a change very quickly, we're not, which is kind of the auspice of number 6, or section 6, is that after a certain time, we make the decision based on the most efficient route possible and not necessarily on seniority. But if we're attempting to remove section 5, I think the best way to do that is to make it to where it's not shift by shift. If someone sends that email, it stays into effect until they send an email repealing it.
And this is something that kind of came up when we had one-on-one meetings with myself, the chief, and the president. For sure, there were issues. It was hard for the department to plan, management to plan, and then too, there were some people who just didn't want to do these tasks. And that was one of my recommendations. Okay, if people feel that way, go on record, put it in writing that you feel that way, and then they'll know better how to plan. Management will know better how to plan, and not put something down and then that morning, right before shift time, somebody says, oh, no, I don't want it. Have them put it in writing, I don't want to be upgraded to these positions, and not then we know. When I say we, I mean the fire department management knows that who they can plan on to better plan and to better staff departments. So I made this recommendation, and I put that one in writing too, in one of my opinions on the grievance, that we handle it this way. And I think if everybody agrees to it, it will help those who don't want to do the task, but it also helps the department in planning for that day's operation.
And just to kind of dovetail what you said, I think that a rejection of the upgrade would have to be in effect for, I would recommend a fixed period of time, not so that we're not just getting kind of buried with emails, which doesn't help trying to plan for staffing.
And that, what I came up with, it was in place until somebody sent a letter rescinding. I no longer want to follow that procedure.
The only other thing I would say to that is that communicating it prior to shift assumes that your deputy chief or the assigned deputy chief for that shift is going to be the one that's there. What if that individual has an emergency and has to leave in the middle of making the schedule? Top of the mind wouldn't be, oh, by the way, so-and-so called and said they don't want the upgrade today, right? That could come while he's on and he doesn't answer, but whoever's in the office making the schedule, it would be helpful for them to have, just like they have a seniority list, to have a list of individuals who have either said that they want to opt out of upgrade, again, for a certain period of time. And that's an easy list to manage, as opposed to sending that email prior to shift or during shift saying, I don't want to upgrade. Because again, the upgrade could, turning down, they would know that, what if they don't know that they're eligible for upgrade that day because something happens in the middle of the shift? An accident, someone gets sick, someone's wife goes into labor, somebody's kid has an accident, and that person needs to go home on an emergency. The next person behind them could say, well, I don't want the upgrade. if we saying that it has to be done at the beginning of the shift, they would be, again, to use your words, forced to do a job that they're really not interested in doing, as opposed to having it in place that, again, to use your language, that if they didn't want it, they've already expressed that they don't want it. So the deputy chief on duty would know to just skip that person because they're on the list, and so that they've already communicated that they don't want the upgrade.
I think that we're saying the same thing. That was a lot of,
Well, no,
Yeah, well, we had to say that, you know, that, we wanted to make sure it was clear what we're saying, you know. We heard what you said, but want to make sure you hear it from us and what we're saying, and we're understanding the same thing there.
there's situations that come up where a person doesn't want the upgrade today or maybe even the next shift, but they're okay after that. You know,
Well, they could-
to send an email, I don't want the upgrade anymore.
Well, I think you can send that email and you're in that status until you rescind it. Whatever status you say I'm in, okay, I'm in it until I rescind that status. It's like, I don't want to be considered. And then you send an email and say, okay, I want to be considered again. There's no time limit on it, basically. But we wouldn't want you to do it every, week or every day. It's just too much to plan for.
I think what we proposed in the city manager, what was proposed is that the individual in writing say that they did not want to be considered for an upgrade, that it would take effect, that they had to do that at least 24 hours before their next shift, that if they wanted to rescind it, they needed to rescind it at least, I think it may have been more than 24 hours, but before their next shift, in order to allow for scheduling. So when that deputy chief came in, they were like, okay, this person's now accepting upgrades, or this person is not accepting upgrades, so that they would know. So if that person worked overtime where an upgrade was available, but they hadn't rescinded it, then they would be passed over for an upgrade. And it just allowed for there to be a trackable document in place. Depending on when the schedule is made, if it's made the night before, or if it's starting to make those overtime calls to fill in the night before, we may need to adjust the time period for when that list that needs to be put in place. But it does need to be in writing so that it's not a situation where they're just telling a person that they don't want it and then changing their mind later on in the shift saying that they do want it.
Right, no, we're not saying that anyway. We're just saying if they let the deputy chief, they could, send it to all of them, so you don't have to worry about who's actually there. But if you let them know ahead of the shift, 24 hours.
Again, it could be a district chief who's been upgraded to deputy that day. I think it does, like, sending it before the shift doesn't allow them to make the necessary changes so that it's properly communicated to the people that need to make the schedule.
And just backing up a little bit, maybe I'm missing something here. But the chief has the right to put people into the next higher classification anyway, right? So the city, in my view, is being generous and giving some flexibility for people to turn that down without any kind of disciplinary action or something else following for refusing to do their job. So I'm a little confused why we're kind of spinning this round and round. It seems like if the city is willing to allow for that to be done at all, requiring that there's some reasonable notification and time constraints on that makes sense.
Yeah, just like we were talking about before, maintenance and standards, this is considered a benefit, temporary promotions. It's been a policy that's been in effect for many years, that this has been offered. So we're not opposed to giving some sort of notice or to giving something in writing, but to say that the city's just doing a favor, I think is a stretch, because it's been an ongoing past practice in the department for many years. However,
Doesn't the benefit come from moving up, though? The benefit is not from getting to say, no, I don't want to take the job and get more money.
But the policy that's been in place for many years says that it is offered to the person, not that it's demanded to the employee. However, to get back on track, we're not opposed to giving some sort of a notice. I think that's where we were going. I think we could speed this up if we just start talking about when we would give the notice. I mean, obviously, the notice would need to be in writing. It's, we could send an email to our deputy chief. Maybe we could word it in the way that you send it to the on-duty deputy chief.
But I also think
that
the
way
key-
we don't have to guess who's going to show up to work the next day as far as the deputy chief
I think we
goes.
also need to stretch that out because it's one of those things where it can't be a day-by-day decision. And it can't fluctuate day by day. It doesn't allow, I think that allows for too many errors and mistakes. That's what we have right now. To your point about this being a policy that's a benefit, this is a contractual benefit because it's an article in your contract. So it's not a benefit delegated by policy. It's a benefit delegated by contractual rights, which is why we're discussing it, because it's a contractual benefit and it's been a source of several grievances. And I think it's necessary for us to kind of hammer it down. So if we're agreed that there's a necessity for it not to be mandatory because that creates an undue hardship, and if we've agreed that it needs to be in writing, I think the next step would be A, how much notice is required, and then B, what length of time it stays into effect. Because making it a day-by-day decision doesn't solve any issues. Making it at the start of the shift, I think, creates additional issues because, again, if an individual has to be upgraded, if something happens in the middle of the shift that calls for an upgrade and that individual couldn't predict the future that they were going to be eligible for an upgrade, if they didn't give notice, are they now required to take it? The answer would be yes, because under the contract,
I agree
if
with
we
you.
put that language in, under the contract, they're essentially screwed. So my thing is,
But that's not what we're saying anyway. That scenario doesn't even make sense for what we're talking about.
it does, because if
No, it
an
doesn't,
individual,
because whether they knew that they would get the upgrade or not, they would send in before the shift that they don't want the upgrade. Whether it gets to them or not is irrelevant. They don't want it if it does get to them. That's what we're saying.
Well, it creates a hardship right before the shift. You know, this is costing us money, with this last minute planning and ability not to plan. That's creating millions of dollars of a hardship on our department. And we need to put things in place that we can plan for and plan better for. And this just allows your people to get what they want. If they don't want to work, okay, fine. But just give us the ability to plan around that thought of what you're doing. We're just looking for solutions. And that's what I'm looking for, some solutions. I've gotten, and we're not here to talk about grievances, but I've gotten several on my desk that pertain to people that morning or the day of saying, I don't want to work, be upgraded. More than several. And so we need to look at a solution for that. And this is a great opportunity to look at that solution for that, because we're just grievance after grievance on the same topic. And this is a chance to help with that topic. If people don't want to work, okay, say we don't want to be upgraded. But let us be able to say that and plan for it and get some people that do. And we can plan, but better planning saves money naturally when you plan better. Yeah. So that's all we're saying. If you're interested in it, we're here to talk about it. We're here to do something about it. And if people don't want to do it, that's fine. But give us the opportunity to operate in such a way that it's efficient for the department.
Yeah, Mr. Williams, those grievances that you're talking about have to do with people that wanted the upgrade and were passed over. Those aren't people that didn't want it.
So
Not the
we know it gives us another tool to work with. We know that these people don't. Some of them were passed over, but one of them was that I came to work and I didn't want to be upgraded. One specifically, I know Cody said that, and that was the big deal because they didn't want to be upgraded. So I think if we put in something in place that addresses that, it might not fix all those situations. It starts to address the problem.
Right. Again,
so what?
we're
so,
okay with the idea of fixing the problem. It's just the timeline that we have an issue with,
So again, so
But
most
we
people,
haven't set a timeline yet. What are we gonna make that timeline? Is it a week? I would think if somebody knows they don't wanna work a week ahead of time, it should be sufficient or something. We can work on that, but 24 hours a day, the morning of, just doesn't give us time to plan.
So what if, because most people, it's a rotating shift. Everybody works at, suppression works 24-hour shifts. So what if we did it 48 hours before? So that would be not at least one shift between when you were scheduled to work, if you send in the email. Or if you had some people who just know that they're not gonna want it, they can put that in their email.
Those are easy. Those are send an email in and you're done. It's the ones that have something happen on a short term and don't want to upgrade for that day. So you said 24 hours earlier. I think we're okay with 24 hours. If there's notification made 24 hours ahead of time, then that's plenty of time for the oncoming deputy the next day to be able to know who doesn't want the upgrade for the shift and to be able to plan accordingly, have a list. I mean, they have lists. I've worked in that position. There's lists for everything. You take notes and that
So
list sits there.
24 hours before the start of the shift. Is that what you're
Yeah,
proposing?
but I think there are some long-term situations where some people don't want to upgrade. And I think they should be able to submit and say, I don't want to work it ever, or for whatever, 2 months. I think there's a short-term 24 hours, but I think there are some people who just say, I don't want to work it.
I think that's, I
And
think
we'll
we're-
give
so-
them the opportunity to say that because we've got a plan for this.
I think there's two different people that we're communicating on behalf of. So the first one would be the individual who just can't work it for that day. They don't want it for a short-term period of time, whatever it is. So that individual would send a notice within 24 hours, but I think that it still needs to be effective into their next shift. So their next regularly scheduled shift. So if they're working overtime, if they have to like stay for a double and working for whatever reason, if they're working for somebody else, they wouldn't get overtime into their next regular shift. So once they send that 24-hour email, it stays in effect into their next regularly scheduled shift.
You mean that they wouldn't get the upgrade until the next
Regularly scheduled shift. So if they're a B shifter and they say at the 24 hours before that they don't want upgrade on that B shift, if they just happen to work a 48 hours on C shift, they still wouldn't be eligible for that upgrade into their next regularly scheduled B shift. And then I think the second one would be the guy who never wants an upgrade. That individual would need to send an email specifically stating, I never want to be upgraded. And that would remain into effect until he sent an email saying, I now would like to be considered for upgrades. That puts the power on the member to suggest when they want it, and it puts the responsibility on them to take that action. So once we receive that email, and I think that the wording would be that it would go into effect, that email would need to be sent prior, again, 72 hours before the start of their shift, and it would go into effect on their next regularly scheduled shift. So if he got off work on a B shift and would, send an email and said, hey, I don't want it, on his next regularly scheduled B shift, it would be in effect. But if he worked any time in between there and overtime, he could possibly be upgraded if, again, that list wasn't updated. It just gives them chance to kind of do that. Now, obviously, it may or may not happen, but the guy who never wants it has to send the email saying that he never wants it, and then he has to send an email saying that he does. The guy who doesn't want it for that 24-hour shift would just say, I don't want to be considered for upgrade on my next regularly scheduled shift.
Just to make sure I followed correctly, we are saying member who never wants it, send an email. Member who doesn't want it, short term, send an email within 24 hours of the shift.
Yeah, so just to
It
recap,
stays into effect until their next regularly scheduled shift. Gotcha. Okay.
I just want to be careful with the word being used of never in this contract. I think it'd be pretty simple. I'm one of those individuals who, for the foreseeable future, I don't care to take captain's upgrade. I never plan to be a captain, and I like to train the younger guys that are under me. However, I have communicated to my deputy chief that I'll let you know in the future in a timely manner if I decide again. But I'm not going to tell him I'm never going to take it.
Well, this allows for
And
you
it's
to.
just for language.
This allows for you to change your mind and
No.
say, hey,
I
I just
changed
didn't
my
want to use the word never in our contract.
I use never for you. I just think in the contract will put someone who does not want to take upgrades.
Right.
And so someone who does not want to take upgrades, I'm using the word never, but they would send an email that says, I don't want to take upgrades.
Right.
The next email that they would send is, I would not like to be considered for upgrades. And so just kind of, and to use your case, you would send the email that says, I don't want to take upgrades. And then when you decided that you did, you would. But the never was just so me and Cody could, to get an understanding on the 24-hour.
Okay, for the sake of time, if you think about that one, then we'll move on.
So we'll have proposed language for that one for discussion for next time.
Oh, that's all you got.
Yeah, I know.
What?
No, you turned it on.
Well, we're at a good stopping point on our end. Unless you have something to bring up, we can address it.
Joe, want to talk about section 6 so we can make it through the rest of that?
Oh, yeah.
Sorry.
Yeah,
Okay.
that's okay.
The same
Same article.
Same article.
Okay.
just
Just the next section, Mr. Williams.
So I guess I guess it's more on, and yeah. The 9 PM thing.
So the last time we talked about it, I think we were waiting for, I guess, like a compromise on time, a good cutoff time.
Yeah, I'm assuming y'all are pretty stuck on this
So
section.
again, it's not necessarily like stuck on it. What we're attempting to do is make sure that it's clear that after a certain time period, it becomes inefficient to do it based on seniority. We need to make the quickest decision possible to get the unit back in service, minimize moving as many, moving the minimum amount of personnel. If you have some guy that you can upgrade at the current station versus bringing a guy across town to do it, I think that would be the most beneficial and efficient way possible. But I think that it's important to have a timeline for when that cuts off, as opposed so that we're not just saying arbitrarily we're going to do it. That it's clear that at this time it's when we do it. So I propose 8 a.m. because I think that the shift starts at around 7. So
Right, so I think from our standpoint, following past practice and the contract and the policy that's in place is the most efficient way to do it. I do understand that once you get into the nighttime, it's definitely not beneficial to anybody to do a whole bunch of moving around, making multiple moves at 10, 11 o'clock at night. During business hours, things happen all day. Changes are made to the schedule. People go home, people move here and there. There's training, there's all kinds of scheduling issues. It's just part of the job. So during business hours, I don't see there being any issue with making schedule changes for upgrades. But understanding that maybe putting something in there might help with some of that. I think we would propose after 9 PM that we would be okay with this language, because then it really is inefficient to move people around at night, in the nighttime.
And so I think I think efficiency, I think is viewed two different ways. So at nighttime, obviously it's not efficient because it's night and you can just kind of make the changes as is. But during the daytime, it's the peak of when things are happening. That's when there are more calls, there's more things, there's more training. And so having to put med units out of service and move and shuffle guys across time would be the least efficient thing possible if you're having to put a med unit out of service for an hour or two to get a guy across town, to get a guy to wrap up a call. So I would like to see that happen earlier in the day so that we can avoid potentially having med units and engines out of service for extended period of times to accommodate one person.
Right. Well, I mean, units get put out of service short term for a lot of different reasons. You know, if there's proper communication, there's not long periods of time where units are out of service, switching manpower around. You just have to communicate with each other and have help moving people around. It's not hard to accomplish.
So what's the policy now?
Now you have to put the engine out of service and you have to go by the seniority list, so there's not really a lot of discretion to do it. You have to follow the list. That's essentially some of the grievances now.
Most of the time, a lot of times the units meet each other places and swap manpower. I mean, it's not, there's ways around this without adding contract language. I mean,
So is it a policy or practice now? Is that what you do? Is it written anywhere?
the temporary promotions is a policy,
Yeah, how it's handled, is that a written policy?
yes.
Okay. And I'm gonna intrude upon Chief White. Come talk to me about this policy and how it works.
Yeah, because I don't get it either.
We thought,
Ooh.
Sometimes I do vertically challenged. Sometimes it's not efficient sometimes to move units across town for one upgrade. It's a trickle-down effect sometimes. I want the upgrade, Station 10 territory. You're out at 14. So now we have to move sometimes more than 2 units or more.
Chief, for people who don't know where Station 14 and Station 10 are located.
Each side of town, difficult sides of town, north versus south. So to move for one upgrade can create logistical nightmare, not only for the personnel, but for the deputy chief, and it's just not efficient to be moving units for one upgrade. Now, we want, if they're deserving of the upgrade, and they have the seniority, then they should get it. But it creates a logistical nightmare. It really does. And as we've seen, it can create grievances also.
Chief, when does this process start? I guess when schedules come out in the mornings or?
Yeah, the deputy
evenings,
chiefs,
or-
as we said, at 8 a.m., they try to have the schedule set. So they don't have to make any moves. But people go home sick, have emergency family leave, things like that. Those things are going to happen. They are going to happen. But we also still have a department to run. And we have to provide a service to the citizens as efficient as we possibly can.
Okay, thank you. That answered my question.
Okay. So just so I'm clear, what is it that your side doesn't agree with about Section 6? I mean, it says that changes will be made in accordance with the efficiency of operations in the department. What is it that you're not agreeing with?
I mean, it just gives the ability for the deputy chief to choose whether or not he gives somebody their upgrade or not.
Okay, so the concern is that a deputy chief is gonna not give a particular person an upgrade?
Right, so all of our temporary promotions are made based on seniority. So with that wording, if anything changes after 8 a.m., then seniority's out the window and he just makes a choice based on what the easiest thing is to do,
Right,
not based on seniority.
okay. So the problem is.
And I
with
know
the-
that it's been said that the schedule's done before 8 a.m., but as far as everybody else in the department is concerned, it's not. Because almost every day, the schedule is not done on the electronic software that we have that shows all of our members what the roster is for the day. They might have it on the physical board in their office. They might have it done by 8 on a regular basis. I'm sure that they do. There's sometimes that they're still calling overtime after 8 just because of how short-staffed we are right now. But that's not always going to be the case, I hope. But nobody knows by 8 a.m. whether or not they've been passed over for their upgrade or not.
So what if we change that to say once it's entered into your, is it ESO system?
Yes, it's ESO.
And this says after 8.
So if we say after it's entered into ESO, so that will kind of put the responsibility on the deputy chiefs. The chief can send out a directive to make him enter before 8 a.m. But after it's entered into ESO.
So the issue that comes to mind with that is if the deputy finishes the ESO schedule, let's just say 8:30 for the sake of the conversation. Nobody knows exactly when it's actually done. Like, I don't think that there's very many people that are sitting there looking over and over, refreshing, waiting for it to be done. So,
But
I
there's a
don't
record.
like attaching a time to it. I don't really like the section at all, but I think you kind of have to put a time to it.
Well, ESO is trackable, so we can pull it up. I guess for the purposes, if someone did say, hey, I was refused an upgrade before it was entered into ESO, you can pull it up and say, again, the steward could request to see the ESO log and be like, no, schedule was entered. To use your example, is 8:30. The vacancy wasn't created until 11. So at that point, it defaulted to what was necessary. The deputy could at that time explain that moving you from 14s to 10 wasn't feasible when there was an individual with same and similar seniority that could have upgraded at that particular station without having to move several people around. So my thing is like attaching it to something that's trackable is the idea here.
Again, we're trying to find efficiency of operations and where we can do that. That's all we're looking for here and how we can do that. And I would encourage the union to help us find those solutions, and you have been. But these are some things we're reaching out there based upon feedback we've gotten, based upon grievances we've gotten, that we're trying to fix some of these things long-term instead of having all these things come up. So if you have a recommendation or something that will help you and us get to that, that's what we're looking for sure. But basically, it's created, more expenses when people come in the morning, and you have to look for double upgrades and put somebody in a position, and it's just, if we can plan better, again, I go back to planning. As long as we can plan better, you can be much more, not frugal, but much more. I used that word too many
Use it again.
times.
It fits.
Much more efficient in what we're doing as a department.
We are appreciative of the offer to try and fix this, and we're on board with trying to find solutions that are gonna address this problem.
Okay, thank you.
And I did not say efficient. You want to come back with something? Yeah, we can come back with something tomorrow. That sound all right?
Is there another one?
The only other thing in that section, the double upgrades in, that was added. It says double upgrade shall not be permitted in operations. Are we okay with that? Not okay with that? I don't think we talked about it yet.
I believe that we're going to be okay with that. However, I'd like to clarify on the intent behind this, or, want to make sure that it's still understood that if the city does promote someone or give someone an assignment that's 2 steps above their pay grade, that these people would still be paid.
Can you give me an
Or-
example?
I'm just saying that if someone is to act outside, act above their classification, then they are entitled to be paid for it. What this reads to me is that means that, well, to me, it means that the city will not be allowed to put a grade 1 firefighter in a position of command or in a position of a supervisory role. And as long as we're in agreement with that, would be in agreement with this language, just to make sure that y'all's intent behind this is not to say, well, we're just not going to pay you for it, but we're going to tell you that you're going to be in this position of a supervisory role. And I have an example. I have an example of a grade 1 firefighter that was recently placed into a supervisory role in the department. He was double upgraded, which we believe he should be because he was put into a supervisory role. However, if this additional language means that you guys are not going to put a grade 1 firefighter in a supervisory role, then we're in total agreement.
So, but a grade 1 that's upgraded to a driver, would he not be in a supervisory role?
That's just, drivers are not supervisors, and that's the single upgrade.
Okay.
But if
so
you
would
were
a-
to put a grade 1 firefighter in a captain's role, then he would have to be paid as a captain. But this would prevent y'all from doing that. And we do have a former grievance that was filed many years ago of, a grade 1 firefighter who was put into a supervisory role. The grievance was awarded in the favor of the local, and that grade 1 firefighter received double upgrade. For my purpose, the way this reads to me, and I want to make sure that it is the same way to you, but this limits your ability to be able to place any of our members any grade 1 firefighters into a supervisory role.
So a supervisory role would be him identified as a captain, is that correct?
Well, it would, depending on what grade they're in, it's a double upgrade.
Well, I'm
So
saying- we're
two
using-
grades above their level.
We're using grade 1 just because that's easy
Right.
for me to understand. So a grade
Right.
1 who is put in the position of a captain, so would be him operating on the engine in the discretion of a captain?
It could be in any supervisory role that fits the job description of a captain.
What's the job description of a captain?
It's fairly long. I wouldn't be able to quote it to you, but it has to do with a captain being a supervisor. Yeah, located on the G drive. I'm sorry, on the what? G drive.
And is there any situation where a captain would operate as a deputy chief?
Only if you
I'm
double
asking,
upgraded them.
I'm asking, like, because you said that there were situations where a grade 1 could act as a captain. Are there situations where
Well, I'm just saying that a grade 1 has been double upgraded in the past. Can the city do that? I'm assuming right now, I guess if the department wanted to double upgrade a captain to a deputy chief, they could. However, just want to make sure that it's clear that they would be paid for that, for acting outside of their grade.
got it?
But ultimately, don't be confused. I mean, I'm okay with the language. I'm just trying to figure out what your intent was for putting it in there, just for clarity.
Was this language address that firefighter would not be double upgraded to a captain?
Essentially, yes.
Okay. Yeah, just trying to get what it means, what the intent is.
And I guess I always try to find answers for myself. So, because, is that not beneficial for the firefighter or person if they're double upgraded? Other than pay, I guess.
Yeah, pays one
They're
issue.
learning, maybe,
Just,
I don't know.
yeah,
if
I mean,
they're learning.
pays one issue, but I mean, I've seen that happen, but the captain is there to mentor the person that's maybe learning more, I guess, leadership. It comes through a mentoring program. I think we were wondering what the intent was. Is the intent not to have a firefighter operate as a captain? Obviously, that would have probably affect operational strength because that firefighter would not have the experience of what now is considered a Beaumont captain.
Okay, I guess I was trying to arrive at, who is it a benefit for? Is it a benefit for that person? I mean, it's not so great for the city because we have to pay a lot higher pay rate
I mean, in
to do
theory,
that. So I don't think, sounds like neither one of us are crazy about it. I'm not sure. Y'all are much more versed at this than I am, so tell me if that's not true.
The example that was given earlier, where you had a grade 1 that was put in a supervisory role on an EMS unit, I think that probably benefited everybody. We're not against that being done, because that person that was put in that situation was a credentialed paramedic, and operationally it made sense, and he was paid accordingly because he was put in a supervisory role. We don't have any problem with that. But just like everything else, if we do a job, then we're paid for it. I mean, that's the whole concept of a collective bargaining agreement. So if we don't want to pay them to be in a supervisory role, that's okay. That's a decision that we can come to an agreement on. But if we don't want to pay them, then we're not going to put them in that position. So, it's kind of a give and take. If you don't want them to be paid for that, then just don't have them do that job. But
Yeah.
it was beneficial for that to happen. And,
And
in this EMS merger that's already difficult, the things that are helpful, I don't think are things that we, want to see go away. But if you want to put the language in there, I don't think it's a problem as long as we're not forcing them to do those jobs that are two classifications outside of their rank.
okay, so the double upgrade should not be permitted in operations. You're okay with that? You mentioned something, mentoring. We tend to forget everything else, but do we have a mentoring program with young firefighters?
We do. The local does. We started it in 2018-ish, 2017, 2018.
Give it a minute and a half version of what that's about, Code, if you don't mind.
So basically, we have booklets that we give them. We provide them information about the union, of course, and the fire service in general. We give them tips on how to make it through their first year. We assign a mentor to them. Each new person that comes in is given a mentor that is theirs for their whole entire probationary year. And any of the issues that come up, that are difficulties for them, they communicate with that mentor, and they get answers to their questions, or they get advice on how to handle certain situations or certain people. So it just gives them that consistent communication with someone, that is tenured in the department and understands how things work, where otherwise they might not get that. Whenever they're in their first year, they do a lot of moving around. They're not assigned to one officer here or there. They kind of bounce around to all of them. So that program was established so that we can give those younger members, a good path into our department and our membership, and really just help them through everything that they need help through.
in the fire services general statements, it's all mentoring. From the minute you come on, I mean, I'm just talking about my experience, you know? Someone took me under their wing and said, hey, this is what you need to do. You know, you're on probation. Listen more than you talk. Don't get in trouble, you know, and I think we're each, you know, if you want to use an old term, we're each our brother or sister's keeper, you know? We work together kind of as a family like that, but there are mentoring occurs, but it's not given a name. It just happens
Yes, and that.
in the culture.
In these discussions, we need to be talking about things like that too, not just that, but we need to, those are the type of things we need to be talking about, I think, too. So, I think, let's keep that on our radar somewhere to do some things like that. But I don't know, for us, double mentoring not permitted, that's what we want, right?
That was double upgrades, not,
Double upgrades, I'm sorry.
not mentoring.
Some people need double mentoring,
Double mentoring, yes. Maybe not the double.
double upgrades. Okay, we're okay, we're on the same page. Thank you. Think that's it. Is that it for you for now?
I give.
Thank you, yeah. And what time do we,
9.
9 a.m., we are reconvened here. Wish everybody a good evening.
Thank you.
Thanks for your time.